Yeah, we're all so busy.
It's crazy.
Kathy, I expect you never felt that retirement could be so relaxing.
I did not expect this at all. I think I'm more busier.
Yeah, sure.
Morning, Rena.
That way.
Good morning. Good morning, everyone.
Hey, Rena.
How's everyone today?
Pretty well.
Awesome. How'd
Good.
you do with your second shot?
Went fine.
Wonderful.
Went fine. Just a little bit of achiness today, but I had that after the first shot and nothing further. So far, so good.
Good for you. Yeah, I've had both, and I came away with having stiff necks from both shots.
Oh,
Huh.
really? Oh, no kidding.
Really?
Yeah.
I get mine on Saturday.
Excellent.
I hope you receive it well.
Oh, thank you.
Yeah.
Yeah, I didn't have any trouble with the first or the second, really. And my wife had her first one 2 days ago, and she didn't have any trouble at all either. So I just had one, the second shot, I had one moment when it felt like what I remember a hot flash felt like years ago. And but other than that, and one chill, and then that was it.
Oh,
So,
okay.
So hopefully it'll go as well for the rest of you. I'm excited that my 2 weeks of my antibodies building up will be over on next Wednesday. So I'm much calmer about coming to Augusta than I would have been before.
I spoke to a constituent this week who had her first shot and went immediately into an anaphylactic reaction.
Oh, great.
Her throat just closed up. Fortunately, her husband was a nurse and could at least take care of her immediate need, but she was asking, where do I go for help? And I said, call the CDC. They had been unresponsive. She was then going to have a workup with an allergist.
Yeah.
But the stuff is so new, I'm not sure that they are going to be able to determine.
Well, they've been tracking it. And they gave you a place to report any significant side effects. I got my shot. I can't remember what it said now because I didn't use it, but so yeah, that's a scary thing. I happened to me after I had my knee replaced, and or maybe it was when I broke. I can't remember when it happened, but that's what happened to me. Is I just so it scared me.
So there are some risks.
Yeah.
I was asked to stay an additional 15 minutes for monitoring.
Yeah.
Oh, same here, Rena. That's standard practice, I think.
Yeah, I don't know if it is for the new one, but it is for definitely Pfizer and Moderna.
Yes. Yep.
But it is pretty exciting. I don't know whether you all know that I spent a year in graduate school studying virology. So I'm like on top of this, in my head, so not that I know the latest facts, but I at least understand the process and why it is that, the fact that they're mutating is not an unusual thing on any virus.
Right.
What they do. Yeah. But it's exciting. I'm excited. I might be able to see my friends again in a month or so, because they're all 60 and up. So they're starting to get theirs now. And so I might even have a hug before the spring is over. This would be a wonderful thing.
Well, we do have a quorum, and it is a couple minutes after 10 o'clock. So I'm going to call the committee meeting to order, and we'll start on our public hearings. This is the meeting of the Joint Standing Committee on the Judiciary. We have 2 public hearings scheduled this morning. We'll take them in the order indicated on the schedule, which is we'll do LD 480 first, and then LD 402. And we will begin with our usual round of committee introductions. And I will just call on people according to our voting list. I always start in a different place on the list. And Representative Poirier, you have the honor of being first today.
Thank you, Madam Chair. Jennifer Poirier. I represent House District 107, which is all of Skowhegan and a part of Madison.
Thank you. Representative Evangelos?
Morning, everyone. Thank you, Madam Chair. Jeffrey Evangelos, House District 91, and I reside in Friendship. And Madam Chair, I have a 4 o'clock call with the Attorney General today, so hopefully we'll get through the work session, most of it anyways. But I do have to sign out at 3:58. Thanks.
Okay. Thank you for letting us all know, Representative. Representative Newell?
Yes, thank you, Madam Chair. Good morning, everyone. I am Rena Newell. I am the Passamaquoddy Tribal Representative.
Thank you. And Representative Libby?
Madam Chair, good morning, everyone. I'm Laurel Libby. I live in Auburn and I represent District 64, which is part of Auburn and all of Minot.
Thanks. And Representative Downs?
Good morning. Thank you, Madam Chair. My name is Kathy Downs. I'm from District 130, which is Bucksport and Orrington. Thank you.
Thanks. Representative Moriarty?
Thank you, Madam Chair. I am Steve Moriarty, representing all of the town of Cumberland and part of the town of Gray.
Thank you. Representative Reckitt?
Morning. I'm unmuted. It's hard to see because something covers it up on my screen all the time. My name is Lois Reckitt, and I reside in South Portland, and my district is District 31, which is the ocean end of South Portland.
Thank you. Co-chair Representative Tom Harnett?
Thank you, Madam Chair, and good morning, everyone. Welcome to the Judiciary Committee. My name is Tom Harnett. I represent House District 83, which includes the town of Farmingdale and the city of Gardner, where I reside. Thank you.
Thank you. And we have a few others who will be joining us in a little while this morning, and we'll have them do introductions when they are able to join the electronic meeting. I'm Ann Carney. I represent Senate District 29, which is South Portland, Cape Elizabeth, the community I live in, and a little bit of Scarborough. And now that we've done introductions, I see that our bill we'll pause for a minute. Representative Babbage is joining us, and I would love to give him a moment to introduce himself as well.
Thank you, Madam Chair. Oh, you can see me. Great. I'm sorry for the difficulty. My name is Chris Babbage. I represent House District 8, which is most of the town of Kennebunk. I appreciate it, Madam Chair.
Thank you. And we have the bill sponsor, Representative Cardone, here to speak with us today and introduce LD 480. Welcome to the Judiciary Committee. I believe you served on this committee before. Is that true?
It is true. I served 2 terms on that committee in the 128th and the 129th. And Soupy has assured me that she's keeping a scorecard. So as soon as we all get back in the building, I'll owe you guys big time.
It's lovely to see you. You may proceed with introducing your bill.
Thank you. Senator Carney and Representative Harnett and my colleagues on the Judiciary Committee. I'm Barbara Cardone. I represent House District 127, which is part of Bangor. And I'm happy to be here today to, at least virtually, to present this bill to you. I wanted to give you just a little bit of a history on this bill and this idea of a right to counsel for persons who are the subject of a guardianship or an adult guardianship or conservatorship petition. The germ of this idea started back in the 128th legislature, actually, when then Representative Bailey and I were part of a subcommittee of the Judiciary Committee and were reviewing what was then the proposed Title 18C, the recodification of the probate code. This idea was brought forward by Leo Delicata, who you will hear from after me, I think. We discussed it a little bit in subcommittee and decided that we weren't going to bring it forward then because it was a new concept or a new idea, and we wanted to get the recodification passed. So in the 129th legislature, I brought a slightly different version of this bill before this committee, looking for appointment of the right to counsel in both guardianship and conservatorship cases. We did have both public hearings and work sessions on this bill, and we did work the bill and redrafted it to call for a presumption of the right to counsel, unless there's a finding by the court by clear and convincing evidence that the person does not need counsel and is in agreement with the proposed guardianship or conservatorship. We felt that it was very important that there be a right to counsel, an opportunity for a right to counsel here. And Mr. Delicata in his testimony will talk to you about the restrictions that this guardianship or conservatorship puts on an adult and why we think the right to counsel is important. Anyway, so we modified the bill in the last session and passed it out of committee favorably in the form that's now before you, the presumption of the right to counsel. And that seemed to satisfy the biggest concern that was raised about the bill, and that was by then Representative and now Senator Donna Bailey, who had concerns about appointing counsel for someone who really didn't want one and didn't need it, and telling that person they would have to pay for it. Representative Bailey was satisfied with the results, with the wording that's before you. We passed it out of committee, and of course, then we adjourned because of COVID, and the bill was never brought to the floor. So I'm bringing it back. I'm asking you to consider it in its current form, which is the modifications, includes the modifications that this committee made in the last session, and that you pass it out, and hopefully this time we will get it to the floor. Thank you. I'd be happy to take any questions.
Thank you very much, Representative Cardone. And I see that there are questions by committee members, so we'll start with Representative Moriarty. You may go ahead, Steve.
Representative Cardone, I just want to make sure we all get off on the same footing in terms of terminology. Can you distinguish for us the differences between guardianship, conservatorship, and a protective arrangement?
Yes. A guardianship is essentially taking away the legal adult rights, and I'm going to tell you that Mr. Delicata can be more articulate than I am on this, but essentially taking away the legal adult decision-making rights that someone has and giving them to somebody else, a guardian. A conservatorship is similar to a guardianship, except it deals with matters of money, of handling financial matters. So if the person has more than a certain certain amount of assets, the ward, they will get a conservator appointed as well as a guardian. The third option, the supervised decision-making, is the newer option that was put into the probate code, I think in the 129th, that is something less than a guardianship or a conservatorship. It's less restrictive and allows for more decision-making, but still may put limits on the exercise of free decision-making that somebody may have.
Okay, thanks very much. If I may ask one further question.
Yes,
Madam Chair, then I'll stop. Representative Cardone, can you tell us why the presumption is not need-based. In other words, if someone has the assets to provide or retain their own counsel, why is it appropriate for the public to pay the cost?
I think if someone has the assets, I'm looking at hang on, I've got to look at the language. Originally, if someone had the assets to pay for it, they would be paying for it out of their assets.
I don't see where it says that.
I think that is, I'm looking to see. It doesn't say that specifically, but that is part of the probate code. Generally, if a court appoints someone to represent if the court appoints an attorney for a person and the person can afford to pay for it, it does come out of their estate. The payment does come out of their estate. And I think that would be in another provision of the code, and this wouldn't be any different. And in fact, that was what Representative Bailey's biggest concern was about the original wording of the bill. She said, if I get someone coming in front of me who says, no, I don't want an attorney, she said, I don't have any problem appointing an attorney that's saying, well, you're going to get one anyway, and the state's going to pay for it, so you don't have anything to lose. But I do have a problem with appointing the attorney and then that you say you don't want, and then you're going to pay for it. So it is to be paid for by the estate of the ward if the person has assets.
Thank you, Representative Moriarty. And Representative Cardone, could you please point us to the direction of that provision, to the that provision of the probate code, either later, as the hearing proceeds this morning, or for the work session? I think having that piece of statute would help us in our deliberations.
The one about payment?
Yes.
Okay, I will get with Peggy about that, and we will have it for you for the work session. I need to get back to AFA. We're actually taking votes today, so
Okay.
If you're okay with that, I will get it for you for the work session.
That's fine, and we can also ask some of the other folks who will be presenting this morning.
Mr. Delicata may have it at his fingertips.
Okay, Representative Libby.
Thank you, Madam Chair, and thank you for being here today, Ms. Representative Cardone. I have a few questions. So they have to do with fiscal and personnel resources. So I understand that it potentially would come out of the individual's estate. If this does not come out of the individual's estate, where would this come from for the budget?
As of now, the counties are responsible. So we're talking about an adult guardianship proceeding or conservatorship proceeding that is in the probate courts. And as of now, the counties are responsible for paying for attorneys in the probate court. So it's actually the county budgets, which seem to be able to handle this without further shoring up. There had been discussion at some point about putting these court-appointed attorneys in the county courts into the MCILS system, but right now they're not. So it's not in the MCILS budget.
Can follow up, if I could, Madam Chair?
Yes.
So as far as the numbers, are there any numbers and a fiscal note as far as how many we could be looking here for numbers that this would affect? I'm thinking now of not just the financial resources, but also the personnel. Do we have the volume of lawyers that would be needed? I don't know, having no firsthand knowledge of this scenario here. Are we talking about, a dozen people a year in a county, or are we talking about hundreds? Somewhere in between is where I'm assuming, but I'd love to have that addressed?
I would be willing, based on my prior experience doing this work, my guess is you're talking more like dozens than hundreds. Honestly, I do not remember from our last legislative session that the fiscal note was a big deal. But I can't remember, and I don't know whether there's a fiscal note on this bill right now. Peggy may have that information at her fingertips.
Is there any concern with this bill, or was there last time, about any kind of holdup for an emergency guardianship, where it could take considerable time to have an attorney appointed? Was that an issue at all?
I'm sorry, I didn't hear you. Considerable time for what?
If there would be, again, speaking of the personnel resources, if there would be, especially in the case of an emergency guardianship, any holdup due to personnel resources, being able to have an attorney appointed in a timely fashion.
I don't think that is generally a problem in terms of getting an attorney appointed. I mean, first of all, we're talking about attorneys appointed in guardianships where people are initially saying they don't want an attorney. If they're saying they want an attorney is appointed. Mm-hmm. So we're talking about in this bill capturing the people who are saying, I don't want an attorney, but they may in fact be incapacitated and not understand what their rights are or understand what they're giving up. But if you're talking about an emergency guardianship where there's a guardian ready to be put in place, and it's just a matter of getting an attorney to speak with the person who's the subject of the guardianship, I don't think that takes very long. I mean, that's a pretty quick appointment by the probate court.
Okay. I have asked so many questions. I will defer and I'll come back if I have more. Thank you.
Thank you, Representative Libby. Representative Harnett?
Thank you, Madam Chair, and welcome back, Representative Cardone, my former seatmate. It's nice to see you. And this is sort of a follow-up to Representative Libby's question, her line of questioning. The Maine County Commissioners Association they're viewing this as a mandate because of the funds that will have to come out of county budgets, ultimately paid by property taxpayers. Do you have a view on whether or not this is a mandate?
If I recall, Representative Harnett, we looked at this last year, and again, I don't have these numbers at my fingertips, but there seemed, each county does set aside a certain amount of money to have court-appointed counsel paid in their county court system. My recollection was that we felt that what was currently being set aside, since it wasn't always used, all of it wasn't always used up, what was currently being set aside was probably going to cover this, these costs. We're not expecting them to be large. And if we are mistaken in that, my expectation or hope would be that the counties come back and let us know that this is causing an overrun for them that they can't accommodate. But our expectation right now is that they can accommodate these costs within their current, within the current amount that they've budgeted.
Thank you, Representative Cardone. And I note there is no fiscal note yet, but I will take a look at LD 531 from the 129th to see what it was.
I think there won't be a fiscal note if there's no cost to the state. I think that's my understanding anyway. So there probably isn't a fiscal note, but it is not our intent. And again, Mr. Delicata may be able to speak to this more specifically. It is certainly not our intent to saddle the counties with a cost that would cause a cost overrun in their budgets. And if we pass this bill, and if that is what's happening, then that does need to be addressed by the legislature, and we need to, we will need to remedy that for the counties.
Thank you.
Thank you very much, Ms. Cardone. Are there any other questions on the part of committee members? Not, so let's see, Representative Libby and then Representative Moriarty. Go ahead, Representative Libby.
Thank you. My question follows on the path of Representative Harnet's, and I just wonder, Representative Cardone, if there has been any discussion, and you did already reference it, I appreciate that, if there has been any discussion around this being an unfunded mandate. And the reason I ask is, if this is telling folks who have already said that they don't want a lawyer, and there hasn't been a process already to declare them incompetent to make that decision, then I would think the presumption would be that they are competent until found otherwise to make that decision. So by mandating that they have a lawyer at the outset, that seems to be a scenario where the county could, whether they have the funding or not, to designate here that they could balk and say, this is an unfunded and unwarranted mandate. And I didn't know if that had come up in the previous session, as you referenced, that this had been discussed already, if any of the county commissioners or anyone had brought that up.
Well, the county commissioners brought up what Representative Harnet had raised, yes. And this is, it an unfunded mandate? Well, we are asking the counties to pick up this cost. But that part of the problem is there's no easy way to get from the counties what this is going to cost them. I did some work on probate courts, not specifically this bill, but on costs and things going on with the probate courts. And it's very, very difficult to see exactly what's going on with the county probate court budgets and how much they're spending for attorneys and how much they might spend on this additional on if we passed this bill. It's just not a straightforward calculation. It depends on a number of things, and it's not clear that they even have records that would allow us to calculate that. It depends on the county. But again, what we did find is that and I can't remember whether it was most or all of the counties, that what they budget for attorney fees on an annual or biannual basis was not being exhausted. And we didn't expect that there would be a burden put on them that would exceed what they had already budgeted. And I'm sorry if I'm not being more specific, but that's as specific as I can be right now.
Sure, I appreciate that. I'm sure it would be tricky to get a fiscal note on it, especially since it's at the county level and it's not at the state level. I just wonder if it just seems that it is perhaps not in our purview to dictate what they do with their spending at the county level versus the state level. Thank you.
Representative Cardone, I wanted to ask you one clarifying question. Does this legislation, this bill if enacted, would it force people who didn't want attorneys to have them?
Well, that's why we put the rebuttable presumption in. If someone says, I don't want an attorney, it would be up to the probate judge to inquire whether, by clear and convincing evidence, whether the probate judge was satisfied that this person understood what they were doing, understood what rights they were waiving and giving up, and that they were giving a knowing and voluntary consent. So if this person is saying, I don't want an attorney, but it's clear to the probate judge by clear and convincing evidence that they're that they really don't understand, or that they don't have the capacity to make this decision or make this knowing and voluntary waiver of an attorney, then an attorney would be appointed.
Thank you for clarifying that. Representative Moriarty?
Thank you, Madam Chair. Representative, I have a gap in my legal knowledge, and that is, where does the right to counsel originate?
You're talking about in the probate court?
Yeah, oh yes, in the probate court.
Okay, I mean, I don't want to go. I don't want to go to the.
Yeah,
fourth
I should have been more clear.
Yeah, I believe it's statutory. That it's under the probate code. It's very clear that a person who says, I don't agree with a petition for guardianship automatically gets counsel. It's the people that what we're trying to capture here are the people who are saying, yes, I agree. I want my daughter or my son or my best friend's nephew to be my guardian, but they might not, excuse me, unwanted witnesses, but they might not truly understand what that is. They might be under a either a false impression, or they might be unduly influenced by some by an outside party to come to cede the power, the decision making that they have, and so it's a check really for the benefit of that person, to make sure that they understand that they are giving up some of their very fundamental rights.
I'm not questioning the need. I'm just wondering what the source was. It's not like the Sixth Amendment, for example.
No. It's a statutory. It's in the probate code, I believe. Mr. Delicata will correct me if I'm wrong about that. No, it's not a Sixth Amendment thing.
Okay. As you know, we've been spending a lot of time with and energy on MCILS issues, and there's more to be spent. As you've acknowledged that these particular attorneys appointed by the probate court do not fall under the MCILS umbrella.
Right. At least as of now, they don't. Yes.
So recognizing the problems that we've seen with MCILS in the criminal context, I'm totally unfamiliar with this. Who trains, supervises, monitors, ensures quality and so forth for these attorneys who are court appointed by the probate court?
Excuse me. They are appointed by the court. They are there's a list kept by the probate register.
Right.
So far as I know, there is no formal training or supervision that these attorneys are given that would be analogous to what you're seeing with MCILS.
See, I'm seeing a parallel problem here. We're struggling with MCILS in terms of training, oversight, competence, experience, and so forth. And yet, apparently, in the probate system, the appointed attorneys have nothing whatsoever to no supervising organization.
Well, and I guess my response, Representative Moriarty, is that's another bill, and it's actually one I have considered bringing. And I think Mr. Delicata can answer this more specifically. There's an argument that they should be under MCILS. Even the statutory wording is a little vague. They aren't right now, but given the issues with MCILS, we, or at least I, thought it was more prudent to tackle the structure of Miklas and what was going on there before we tried to shoehorn yet more attorneys into the MCILS program, because in fact, these attorneys would bring a whole different pool of knowledge, expertise, needs to what MCILS would need to supervise and train. A probate court attorney, someone who's advising people in probate court, is advising on a whole different set of issues than someone who's advising someone in criminal court, and even someone who's advising on child protective. So it would be yet one more area that MCILS would need to absorb. I believe.
I'm going to, Representative Cardone, I'm sorry to interrupt you, but I do want to just remind everybody that we can only do a public hearing on the bill that is before us. And this MCILS issue takes us in a very different direction than for example, the supervision that probate courts exercise when they're approving expenditures and that sort of thing. So it's an interesting discussion. Let's save it for that piece of legislation.
Okay.
Is that okay? Thank you. Representative Moriarty, did you have any additional questions?
No, I think not at this point. Thank you.
Okay, thanks. Representative Libby?
Thank you. So I have only been familiar with guardianships in the area of hospitalization in my prior work. So I'm just wondering if you could explain to me, since this is a new area in guardianship and conservatorship, at what point and what is the process for an understanding of capacity or competence to make decisions? Where in the process does that happen? Is that something where there's a social worker assessment involved, or is that purely to the purview of the probate judge, or where does that come into play, that piece of it?
Well, if someone believes that a guardianship or conservatorship is necessary, that person files a petition in the probate court to have just that issue adjudicated. So that is the subject of the guardianship or conservatorship petition, the competency question. It could be any number of persons. It's not just in a hospital. Someone needing someone in a hospital needing the hospital needing a decision. That's kind of a smaller subset of what's going on here. Yeah. But that's for the judge to make. So this issue of counsel really needs to be decided before the adjudication of capacity or incapacity, so that the attorney can assist this person going through that proceeding. Does that answer your question?
Somewhat. So you're saying in basically that delineation of competency does fall to the judge, and there's not a linear protocol. There's no set standard to decide that. Is that correct?
Well, the judge has a set standard.
The judge does. Okay.
The judge, there's a standard in the statute. The judge has to find that, and I'm sorry, I can't recite it offhand, but the judge has to make certain findings that show that this person is incapable of providing A, B, and C, or is incompetent. But that is the role of the probate judge in the proceeding.
Okay, so that I would love to have a copy of that if I could have access to that somehow through Peggy, or know what that looks like, that the judge is looking at for competence. And is that early in the process?
That is the process. No, that's the subject.
That's the entire.
Proceeding.
Okay.
Yeah, that's the question that the judge ultimately has to decide.
Okay. So then really being able to turn down a judge can't happen because that's the entire process. Being able to turn down an attorney can't happen because the process will be completed by then and it will be decided?
Yeah, if someone says, well, first of all, if someone's contesting the guardianship, they will have an attorney.
Mhm.
Even if they say they don't want to have one, the court's going to appoint one. That's what happens if there's a contested guardianship. But if someone is not contesting the guardianship and they say, I don't want an attorney, then if an attorney isn't appointed for them anyway, the guardianship goes through, they're under guardianship, and they really haven't had a chance to talk to an attorney about that. I mean, I'm expecting in a number of these cases, just so you understand, I'm expecting that in a number of these cases where if a court finds that there's an attorney, that an attorney should be represented, even if the person is saying, I don't want an attorney, that an attorney is going to step in, an attorney is going to talk to the person who is going to come under guardianship. An attorney's going to talk to the guardian, and an attorney's going to, do due diligence in this, and ultimately say to the court, I've spoken to my client and this and this and this, and yes, I am satisfied that it's appropriate that an attorney be appointed here. I don't think an attorney is going to step in and start fighting all of this this whole thing against the will of their client. And unless the attorney finds something very serious that the client may be unduly influenced, or the client the client's rights may be in danger and the client doesn't realize that. That's why we're looking for this, for protection of the client.
Thank you.
Thank you very much. And I don't see any further questions from members of the committee. So at this point, Representative Cardone, we thank you very much. Are you planning to stay for the rest of the public hearing, or are you heading off to AFA?
I need to get back to AFA, but Soupy has my cell phone number, and as does Mr. Delicata. So somebody can feel free to text me or call me if you need me, and I'd be happy to come back on.
Okay, I think you've answered all of our questions very well, and we'll see you at the work session. Thank you very much.
Thank you.
At this point, we will have Mr. Delicata join us, and I believe he is coming over from the participant list, and here he is. Mr. Delicata.
Yes.
We appreciate your being here today for the hearing on this bill, and you may begin. We typically have a 3-minute limit, which I'll do the timer, but please understand that we'll probably have questions for you as well.
Thank you. Thank you very much, Senator Carney and Senator Carney and Representative Harnett. You should have my testimony before you. It's quite extensive, and it does reach some of the questions that I've heard so far, but I'm more than happy to try to answer some of the questions that are perhaps not clear in my testimony. The first point that I'd like to make is that guardianships and conservatorships and other protective arrangements are really extremely serious proceedings. And, at worst, they have the ability to really remove all of our adult legal rights, or at least some of our adult legal rights. So it's important that you get some help if somebody has brought a petition against you for any of these proceedings. And the probate code now contains reasons why a judge should appoint an attorney. And what this bill does is it shifts the focus. And it doesn't require the appointment of counsel, but it asks the court not to find reasons why an attorney should be appointed, but to find reasons why an attorney shouldn't be appointed. And it also is very clear in making sure that those people who don't want counsel and are able to articulate that have their values and preferences about how they want to proceed respected. But it does so in a very clear way by requiring the judge to use a very high standard of evidence to try to make sure that this decision that people are making is an informed decision and one that they're doing voluntarily. You know, this is analogous really to the kind of, and the probate code, the whole guiding principle of the probate code is that people's independence and autonomy and self-determination should be maintained as much as possible. The old code was basically had a full guardianship as the default. So there were a lot of full guardianships under the old code. The new code takes a different tack and basically is saying, look, we presume that everybody has capacity and we're not going to impose our will on you and change that unless we can find good reasons why not to, or why to do. Section 5301 of the code has the basis for the appointment of a guardianship, of a guardian of an adult. And one of the sections is really analogous to what this bill does. And it says that the court can appoint a guardian if it finds by clear and convincing evidence that the respondent lacks the ability. So they start off with, you have the ability. We're only going to do this if we find you lack the ability. And one of the bases for the appointment under this particular section of the code, which sets forth really the rules for the judge, is the respondent is unable to receive and evaluate information or make or communicate decisions, even if he has or she, even with appropriate supported services, technological assistance, or supported decision-making that provides adequate protection for the respondent. So it forces the court to look at those things that someone who may have some apparent problem can use to convince the court that they don't have the problem. And if you have some assistance and it allows you to make and communicate decisions, then the judge can't use that particular provision to find that you're incapacitated. So,
yeah. The 3 minutes is up. So if you can wrap up, I know there will be questions as well.
Okay, I will wrap up and essentially will rest on my testimony. But the one thing that I would like to leave you with is really on the last page of my testimony, and it's a question that Representative Moriarty actually asked, and it's about the basis for all of this. The Maine Constitution says the following in the first section of its Declaration of Rights: all people are born equally free and independent, and have certain natural, inherent, and inalienable rights, among which are those of enjoying and defending life and liberty, acquiring, possessing, and protecting property, and of pursuing and obtaining safety and happiness. That's different from the federal Constitution because it says defending life and liberty. And the idea that we have the right to enjoy life and liberty, and we also have the right to defend the same, seems particularly germane to legal proceedings where the loss of liberty is at stake. So I'm happy to take whatever questions you have for me.
I'm going to start with a question for you, and I appreciate you connecting this to the rights established in the Maine Constitution. So basically, this provision is designed to come into effect when someone has been subject to a petition for guardianship that they're not the moving party. Somebody else has brought that petition, and their independence and autonomy and self-determination is basically going to be taken away from them by the probate court. And this gives them a presumption of a right to an attorney to help them address that pretty significant challenge to their autonomy. Is that correct?
Absolutely. It shifts the focus from find a reason to find a reason not to appoint.
And if they are competent and are able to decline counsel and meet that standard, then they can decline counsel. Is that right?
Sure, absolutely. And one of the examples that I can think of, and it's an example that was discussed last year, was the person who was in the early stages of dementia, or somebody who's diagnosed with ALS or some kind of horrible neurological disease and really doesn't have close family, but has somebody in their life that they would like to have appointed for those times when they are no longer able to make their own decisions. Now, that person might get the help of a lawyer to put together a petition for guardianship or conservatorship and come into the court with or without the lawyer and ask the court to make a limited order or maybe a full order that would spring into effect at some point, or maybe immediately. And that is the kind of person that I think the prior committee was satisfied would not be affected by this presumption, because they could make a knowing and voluntary refusal. So it doesn't require the appointment of counsel. It simply says to the judge, look, under the current law, you have to look for a reason to appoint. And what we're asking you to do is to look for a reason not to appoint. In neither case are you required to appoint.
Can you gave us an example of somebody who could meet the standard under the statute and not have appointed counsel? Can you give us an example of a situation where this statute this bill, if enacted, would really accomplish an important and significant purpose?
Yeah, in fact, I give you about 5 examples in my discussion in the testimony of the current law. And an older person with some cognitive issues that is living in the community and has been in the community for a very long time, it may not particularly have a lot of people around them, and they may have one particular individual that's their entire life that does a lot of things for them, and that person may be bringing the petition. And so when the visitor comes to see this person and asks this person whether they want a lawyer, which the visitor is supposed to do, this adult may not say anything and may not contest anything, because they're really afraid of alienating this individual who's the only person in their life. Now, we've seen cases where these individuals are really the people who financially exploit older adults. And there's no guarantee that without a lawyer to represent this individual, they would be free of any problems. The current code does not have any requirement that the judge have an affirmative obligation to examine the person who could be subject to the order. That generally is something that the courts defer to a visitor to do. But in this case, under the presumption, the judge would have to be satisfied that this was a knowing and voluntary waiver. So it adds a layer of protection. It adds a layer of something we don't have in the current code to reach some people who are really in necessitous circumstances, but are also in a very risky situation and could be taken care of, taken advantage of. And having a lawyer who develops a relationship with this individual, gets to know what their values and preferences are, gets to know a bit about, maybe a lot about this one person in this individual's life, could go a long way to getting somebody involved who has no other interest but the interest of this individual in mind, who could advise the court. Is that what you're looking for?
Yeah, thank you. That's very helpful. And I know that committee members have questions, and I'm going to call on Representative Moriarty in just a second, but could you just, I know that you appeared before the committee when we were doing our introductions. Could you just give us a sentence or two about what your role is and why you're engaged in supporting this legislation?
Sure. My name is Leo Delicata. I'm an attorney with Legal Services for the Elderly. And I've been with the organization for over 30 years and I have a pretty extensive understanding of the problems, legal problems that older people have in the state. And I've been very involved in all legislation, a lot of legislation that has to do with this committee and other committees that have the interests of my clients at heart. And this in particular has been something that I've been interested in since the Uniform Probate Code was suggested in this state. I commented on a lot of sections of it, and especially commented on the section that dealt with the appointment of counsel, because there were two options. One was to appoint counsel in every case, and the other one was what we got, which the Uniform Law Commission in their comments essentially say will require the appointment of counsel not require, but result in the appointment of counsel in virtually every case, but not every case. And they weren't just talking about the voluntary and voluntary refusals and informed refusals. So we've been trying very hard to make sure to, and this is really what this bill does, is it improves the probability, it raises the probability that an appointment a lawyer will be appointed. It doesn't require it, but it raises the probability. And, in circumstances like this, where, your rights might be affected in the same way as somebody who has an involuntary commitment for mental health, or somebody who's facing a conviction for a criminal offense. We really feel that we ought to raise the probabilities that an attorney would be involved.
Thank you very much. Representative Moriarty, you can proceed with your question.
Thank you, Madam Chair. Mr. Delicata, can you describe the role of a visitor?
The role of a visitor is in the code, and it's clearly spelled out. But I can tell you that the role of a visitor really depends a lot on what the qualifications and the experience of a visitor is. And one of the problems is that it's not a problem. One of the realities is that there is no official training required for a visitor. There is no curriculum that a visitor can look at. And so if you ask me what the actual role of a visitor ends up being, what I'll tell you is if you've seen one visitor, you've seen one visitor. And that is something that I think has concerned us and concerned, frankly, the probate court for a long time. And we have tried over the last 5 years to come to a point where we can get together and create a uniform curriculum that could be used. It's a real lack. But so judges, the role of a visitor is to be the eyes and ears of the court, to be the fact finder for the court, to go into the home, to understand who the individual is, and to explain to them what the petition is, find out if they want an attorney, and ask them if there's any part of the role of the visitor, role of the guardian, or the role of the anything in the proceeding that they want to contest. That happens differently with every single visitor. And so I can only answer your question in a theoretical basis, but I can't tell you what happens on the ground.
Okay, I think you've answered the question, and we're sort of moving beyond the scope of the bill. So I'll just ask a different question. The current bill, as I understand it, imposes or creates a rebuttable presumption of entitlement to counsel upon the filing of a petition. Correct? Am I right so far?
Well, yes. I mean, you cannot, this bill doesn't work unless a petition has been filed.
Petition is the triggering event.
Right.
Okay. But the presumption, although rebuttable, can only be rebutted upon a showing by clear and convincing evidence of the lack of need or desire for an attorney. It's not enough to simply say, no, I don't want one.
It's not enough to just say, I don't want one, unless the court is satisfied that you've done so in a voluntarily and knowingly. And so it presumes.
But again, just satisfied by a relatively high degree.
Right.
Okay. And one final question. One of the registers of probate has submitted some written testimony and has identified section 5-305 of the code as the source of entitlement to counsel. I don't mean to quibble about what section it is. I guess we can pursue that, but is there just one section, or are there several? Or
well, the section that deals with the appointment of counsel is, I think that's the basis for believing that there is a right to counsel within the probate code.
Mm-hmm.
And unfortunately, it's not an unqualified right. You have to find a reason under that section to appoint.
Okay. All right. Thank you.
You're welcome.
Thank you, Representative Moriarty. Representative Newell, did you have a question?
Yes, thank you, Madam Chair. Mr. Delcada?
Representative Newell?
If you would, I think I've framed my question. If not, please ask me to reframe it. Would the appointment of counsel apply to individuals placed under DHHS adult protective services in the absence of a private guardian or conservator, following the petition that has been previously mentioned?
Yes. Yes. Any guardianship that's brought will trigger an obligation to determine whether an attorney should be appointed. That's what happens now. And that's what will happen if this passes. Doesn't change the obligation to decide whether an attorney ought to be appointed. Now you have to give a reason to appoint. And if this passes, you have to give a reason not to appoint.
Okay, thank you.
Thank you, Representative Newell. Representative Libby, I know your hand is up, but Representative Poirier actually hasn't asked any questions yet today. So I'm going to start with you, Representative Poirier.
Thank you, Madam Chair. I would like to know approximately on a yearly basis about how many of these adult guardianship cases do the probate courts see?
You know, I don't remember the exact number. As I recall, Kathy Ayers, who was the register for Kennebec County, provided statistical information like that to the committee. My recollection, and I may be wrong about this, but there are approximately 3,000 guardianships that are filed statewide on an annual basis. I may be wrong about that, but that seems like a number that makes sense to me.
And Madam Chair, may I ask a follow-up?
Yes, go ahead.
And in researching this bill, do you have any kind of estimate what kind of percentage of those would require this bill to take effect and utilize the court-appointed attorney for that purpose?
Well, honestly, I'm not quite sure what you're asking. If you're asking, are more attorneys going to be appointed or less attorneys going to be appointed if this passes?
I guess that would answer my question.
Yeah, I don't personally, I don't see a huge uptick, if any, if this passes. I mean, it will be a different analysis. That basically is it. And you know, the real advantage is that there is going to be a closer examination of what the individual wants. So I don't really know. Honestly, I think that some probate courts have a difficult time getting attorneys, period, because there aren't a lot of attorneys in some counties. But again, that's an issue. That's a systems issue that, you know, like the visitor issue, it's a systems issue that we're going to have to deal with.
Did you have a follow-up question, Representative Poirier? Thank you. Representative Libby, go ahead.
Thank you. And helpfully, Representative Poirier asked a significant portion of my question. My question with the 3,000 guardianship cases per year, it would be nice to have some numbers for the work session regarding what percentage of those are with or without counsel at this point. I don't know if we can get that from the counties or what, but it would be nice to have those numbers to have some idea of what a fiscal note would look like. And then I guess my follow-up to that would be, do we have any numbers as far as per case then that could be applied that would be the cost per case so that we can have some sort of fiscal note?
Yeah, I have no idea what the average cost per case is. My guess is that each county pays a different rate. Maybe I'm wrong about that, but you know, when probate judges decide whether to appoint counsel and who's going to pay, they do use the same approach that's used by the judicial branch when in criminal cases people have to prove indigency. I don't know whether they use the same form, but there is in the rules, in the criminal rules on the judicial branch side, there is a form, and I think it's Rule 44 or Rule 45, but there's a form that the judicial branch uses in a uniform basis to determine indigency. And I expect that that's the same process that's used in the probate courts. But you know, you've got 16 different probate courts, 16 different probate judges, and everybody has the ability to do it differently.
So follow up to that, if that's okay, Madam Chair.
Go ahead.
So if someone has said that they do not want an attorney, and one is appointed for them and they are not indigent, does that require that the money then come out of their estate at some point, or is this going to be the county paying for that?
I think that the probate court, I know that the probate court judge has the ability to order that the person subject to a guardianship or a conservatorship, their estate is charged. Now, whether their estate has, the judge ought to know by that point whether there's money or there isn't money. But to answer your question, the probate court judge has the ability to make an order that an individual pay for the services. And, my guess is that if the individual refused and it was a voluntary, informed refusal, there wouldn't be a lawyer. So there wouldn't be that problem.
Okay, so that would come up then if they refused and then were found throughout the process to be incompetent, and then would be charged for that lawyer through their estate. Is that correct?
I'm sorry, I couldn't hear all
Sorry.
of the words, but in that, and I'm having a very difficult time really envisioning a situation where somebody made a knowing and willing refusal and yet was found to be subject to. In other words, the judge actually made an order that would make that person a person subject to it. That person would have a guardian or a conservator.
So that decision on the financial side of things would be left to the judge's discretion?
Yes, absolutely.
Thank you.
Representative Newell, did you have a question?
Thank you, Madam Chair. I'd just like to follow up on Representative Poirier's question, as well as Representative Libby's, but it also goes back to my previous question. You mentioned there were 3,000 guardianships filed annually, approximately. Is that data that reflects anywhere that could be provided to the committee? And I'm particularly interested, again, following my previous question, in regards to the number of state guardianships.
All of that information is available. I don't have it in my mind. And the 3,000 figure, I think is accurate, but I also really may be making it up. I don't have a clear source that I can point to right now. I mean, I know that somewhere in my files, I've got all that information. Whether I can retrieve it or not, I'm not sure. But Kathy Ayers is the source that you want to talk to in terms of getting those figures.
And she is here.
Kathy, if you're listening, I'm sorry.
She's here and we can call on her
Right.
next, potentially.
Thank you.
Are you all set with your questions, Representative Newell?
Yes, Madam Chair, thank you.
Okay, we've noted your requests. Representative Moriarty?
Thank you, Madam Chair. I wanted to follow up on Representative Libby's question. I assume that if an estate has no assets, a very modest amount of assets, that the estate will not be charged for the cost of counsel. Is that your experience?
Yes.
Okay.
I mean, yes.
So then, in such a case, the county would pay for the cost of representation.
That's my experience, yes. The county would pay, the county is supposed
Okay, so I
to
keep
pay
coming.
when individuals don't have the ability to pay.
Okay, so I'm just coming back to the analogy to MCILS. In the case of someone who is unable to pay, does the judge examine the invoice from the appointed attorney? Does the court system keep track of hourly rates, and how much of a person's practice is devoted to court-appointed representation?
Those questions really would be better directed to Ms. Ayers, but I am virtually certain that the court doesn't keep track of what percentage of an individual's practice is probate law. In fact, I think that there are some courts that are just happy to be able to have attorneys that will agree to be appointed.
I'm sure.
You
I'm
know,
sure. Thanks.
It's interesting, but the MCLIS statute actually does, again, I'm going from memory, does mention guardianships. And I think that there are not adult guardianships, but I think there are guardianship situations where at least the statute allows them to appoint. And
Yeah, I think there are cases involving children, as I recall.
that may very well be. Yeah.
Okay. Thank you.
Yeah, thank you. Any further questions for Mr. Delicata? Not seeing any. Thank you so much for all of the information you've provided. And we will invite you back for the work session and also be in touch with you regarding some of the requests for information.
Thank you, Senator Carney. And thank you very much to the members of the committee for your courtesies.
Thank you. At this point, what I'm going to do is I'm looking at the attendee list, and I would ask anyone else who is present in the electronic meeting who wishes to testify in support of this legislation to please raise your electronic hand so that I can see who you are and call you into the meeting. These are people speaking for the measure. Okay, I see Stacy Converse, and I will bring you into the meeting. Thank you very much. And if there are others who are in the attendee space who wish to testify for, please keep your hands raised and we'll be with you shortly. Ms. Converse, you can proceed when you're ready. Ms. Converse, have you successfully transitioned into the meeting? There you are.
I made a comment that I couldn't see myself and thought everyone agreed. So my apologies about that.
That's right. We can see and hear you, so you may proceed.
Okay. I'm Stacy Converse, and I am the managing attorney at Disability Rights Maine for our developmental disabilities program. Like Mr. Delicata, I have over a decade of experience working with individuals who are subject to guardianship. The individuals I represent are individuals with developmental disabilities, such as intellectual disability or autism. Frequently, these individuals are placed under guardianship when they turn 18, and frequently it's done by a parent, a well-meaning, oftentimes parent, and without really knowing what the implications of any sort of consent to guardianship would be. And I think they feel a lot of pressure to agree with the family. They may live with their family. They want to go ahead and do what's right. And the visitor comes out and they may just consent to it because their parents have told them that's the right thing to do. And so I think every person should have an opportunity to consult with an attorney before they give these rights up, because I think at 18, I couldn't do that. I would have been, I would have agreed with whatever my mom said because she's feeding me and I'm living under her roof without really knowing the implications of that. Unfortunately, frequently people who are placed under guardianship, it ends up being a lifelong appointment. We do a lot of termination work for people with intellectual disabilities and autism. The only other thing I would really suggest is perhaps considering expanding this presumption to include people who go to terminate their guardianships. So frequently people will reach out to the court, want to terminate their guardianships. And there are a number of procedural obstacles that come before them that they're really not able to navigate. So it would be things like, they don't have income for an attorney, so filing a financial affidavit so that you can get your filing fee waived and you can get an attorney appointed. Some of those barriers are huge, and a petition isn't accepted until some of those are cleared. So I would just urge you to consider expanding it to include petitions for termination with the presumption of appointing counsel. and I'd be happy to answer any questions.
Thank you very much. You came in way under the time limit.
I talk fast. Sorry.
You did great. Could you please provide us with the citation of the section that relates to termination of guardianships?
I can, if you can just give me 1 second. I just had it up. This is the nice part about doing this all by computer. I just had it up. It is it's 18C 5-319.
Thank you very much. Committee members, are there any questions for Ms. Converse? Not seeing any. Thank you very much for presenting today and for your conciseness.
Thank you.
I'm now turning to those who are in the attendee portion of the meeting and asking it one final time, anyone else here to testify in support of this legislation? Not seeing anyone. Is there anyone here to testify in opposition to this legislation? Ms. Ayers, I will bring you into the meeting. And once you join us, you may proceed.
I can get my audio.
Yeah, we can hear you, but we can't see you.
Well, let's start the video. Sorry. Here we
That's
go.
all right.
Great.
Welcome.
Thank you. Thank you. I'm just going to read from my speech first, and I did turn it around a little bit. Honorable Senator Carney, Representative Harnett, and members of the judiciary. I'm Kathleen G. Ayers, Register of Probate for Kennebec County and President of the Maine Association of Registers of Probate. I want to start with some real life examples of why attorneys are provided, including a refusal for food, medications, medical treatment. A person may not want to leave or sell his home, their culture or preferences that are not being respected. They want to smoke, they want to go to a specific church or eat a certain food. They do not want to be separated from their spouses, their partners, their pets. One veteran even wanted to go to the casino occasionally. These are all reasons why we would appoint an attorney. The association strongly opposes this legislation for the following reasons. The clear and convincing standard of evidence is a very high bar, and to prove it, there will need to be proceedings and findings before the many new layers of protections and proceedings within the Uniform Probate Code. It essentially means an attorney for every case. There are not enough attorneys to comply with the criminal cases, and there is a shortage of attorneys willing and available now in contested guardianship matters. It could potentially set up conflicts within families when attorneys are not wanted. This will cause significant delays in proceedings. The Uniform Law Commission, after years of study, did not recommend this. Appointing an attorney is already required under 5305 if there is any suggestion of objection or limitation by the respondent. Part of the court visitor's duties are to find out whether the person objects to any aspect of the impending guardianship. The cost of the county property, the cost goes to the county property taxpayers, to litigants and families who are in agreement. That is an unnecessary mandate. Partly due to the fact that county probate courts are not included in the indigent legal services and only on appeal because it is a constitutional issue and our cases go directly to the law court. Sorry, I added that. Forcing someone to pay for an attorney they don't want. We don't want to do that. And we're not aware of any problems of an attorney not being appointed in these situations, especially under the Uniform Probate Code. Last but not least is the situations where families without means will back out of becoming guardian, leaving a relative in a bad situation and adding to the already large caseload of DHH as adult protective public guardians. This is already happening. And it's happening because of the new code and the proceedings and the requirements of the new code. And I said just Kennebec County, but when I circulated the speech, I got other counties that said the same thing. No pro se mother wants to go up against an attorney. It is, you know, granted, there would be negotiations, but please ask me questions about any of the procedures, because a lot of this and the numbers are hard to get. But I do have the 2018 numbers that we collected for the making of the new code. And we're not against attorneys. I just did a quick review of my numbers, and we've had approximately 60 guardianships this year, this last year, and we appointed 23 attorneys. That does not count the people who come into court with an attorney already, which is most of the time the case in conservatorship cases. Where there is money, there is usually an attorney, they come in with one. And also there is, we have to find that they are competent before we even have, you know, the visitor go out. Before we do have doctor's reports starting. You know, you have to begin with a doctor's report. So I'm rambling now, and I will calm my heart down a little bit, and you can ask me some questions.
All right. I think having some questions would help frame the issues a little bit, and we do appreciate you being here today.
Yes.
And I see that we have a question from Representative Libby. And so you can go ahead, Representative Libby, and then Representative Harnett.
I am sure that there are going to be many questions, so I will limit myself to one for starters. Thank you, Madam Chair, and thank you for being here, Ms. Ayers. My first question is simply, I'm not familiar with you referenced the numbers from 2018 for making of the new code. I'm new to all this, so I would love to hear more about that for starters. Thank you.
Sure. Well, Leo, when he said the 3,000.
Can I just clarify, are you asking about the whole process for the new probate code, Representative Libby? Or
I am not.
okay.
The question is to not the entire probate code, but just as applies to this particular issue. So
how we came to have this bill before us, is that what you're asking?
Yes, in part, yes.
Okay, thank you.
Thank you.
Well, the Uniform Probate Law Commission studied this, and we're the first in the nation to have this code, this probate code, the new probate code. So that's how it came to us, and it has more layers of protection than the old code had. It has shortened timelines for hearings. It has more in-depth visitor reports, more in-depth findings that the judge must find before, and it's a lot more labor intensive than it was, but it is in protection of people who are under guardianship and are losing their constitutional rights in some cases. But that's how it came to be. And when Leo said there were 3,000 cases, that is the total number of guardianship proceedings. So there is approximately 1,000 a year in new guardianships cases. It may be over that. It was 1,036 in 2018. It may be more now, but the number he had included guardianships of minors, and it also included the terminations, the single transactions, and that's guardianships, conservatorships, and the joined petitions, which include both. So I just wanted to correct that to start with.
One quick follow-up to that, then with the numbers, if that's okay, Madam Chair.
Yes.
So with that 1,036 in 2018, and thank you for providing concrete example of numbers from a year, is it possible to know how many of those, as you said, with the 60, 23 had attorneys appointed, is it possible to know how many of those 1,036 were without representation and that under this new statute the change to the statute would require appointment of an attorney?
It's really difficult to get numbers, and I'll tell you the reason why. Not that it's an excuse, but we have an electronic filing system now, and attorneys file their work. And if they don't code things properly, then they don't get into our accounts. So this problem came to our attention in 2018, and it was very laborious, and not much has improved, as I found out today, in that area. So, but obviously in our court, it's at least half of the people who go under guardianship, if not more, because we don't have a way of counting the people who have their own attorneys when they come in. So it would be very labor intensive. It would probably be, going through the cases one by one in a lot of counties and looking at them. So I'm not saying it can't be done, but they're pretty busy people.
Thank you.
Yep.
I just want to interject a quick clarifying question. You said that of that 1,000, you think approximately one half of them are already have attorneys involved?
Well, I'm going from my numbers, and that is, I had 60 guardianship cases, and we had 23 appointed, and I counted conservatorship in my counts, and 23 were appointed by us. And then there were, like I said, there are other attorneys, and I think it's a fair guesstimate to say that it's 50%.
Thank you. I just wanted to clarify. Okay, Representative Barnett, go ahead.
Thank you very much, Madam Chair. Nice to see you again, Ms. Ayers.
You too.
You talked about the Uniform Law Commission, which involves a lot of attorneys from a lot of parts of the country, and you stated that they suggested the standard that is in the current law in 5305 of the title, and rejected the one that is being recommended in the LD that we're considering today. Do you know what their reasoning was?
I do not.
Okay. Thank you.
Representative Moriarty?
Thank you, Madam Chair. Ms. Ayers, I want to ask you about the standard that's applied in section 5-305 in the current code for appointment of an attorney.
Sure.
How does that happen? And can a person decline the appointment? And if so, what sort of showing needs to be made by that person?
I honestly can't remember anyone declining after appointment.
All right.
There are some people that do object to an attorney. And I live in the land of Riverview, so that does happen. But I just wanted to go over the whys, and their appointment, if they're requested, if the visitor recommends it, if the respondent needs it, if it comes to the court attention that they wish to contest, those are the reasons why we would appoint an attorney.
Okay, and so once the appointment is made, is there any, so your experience is that people don't decline the appointment once it's made?
We've had clients completely refuse to cooperate. That's what happens. They do not cooperate with the attorney.
But the attorney is still on the case.
That's
when
right.
it happens, right?
That's right.
Okay, thank you.
Representative Poirier?
Thank you, Madam Chair. And hello, Ms. Ayers. You did already touch on part of my question. I was going to ask you as far as the professional recommendations from the doctor, so I appreciate that. And to go along with that as well, my question was about the process in place now. And I would like to have some clarification on what the selection process is, or who are the people that are utilized as the visitor.
Right. So I want to, from my court, it's we have a plethora of skilled visitors. So when we have a person, say at Riverview, we have professional psychologists retired. We have special social workers, and we have nurses, and we also have some people who are educators who have disabled children themselves. In smaller counties, I think perhaps there is a smaller pool of people, but we have visitors that are very seasoned. You know, they routinely do these cases, and they may not have any training, but they usually retired educators, retired attorneys. We have a good pool of people. We're also working on, and thanks Leo Dakota, we are working on a training program for them. We've had a training to go over process at the beginning of the code with all the visitors in the state. The registrars and the visitors got together and did that. But we do try to find people with the right skill set for the right situation.
Thank you.
Thank you.
Right, at this point, I'm not seeing any further questions for, oh, we do have another question on the part of Representative Sheehan. Go ahead, Representative Sheehan.
Thanks, Madam Chair. Sorry for jumping in at the last minute.
Oh, I'm glad you did.
And I am also very new, so I'm super unfamiliar with these standards. And I just wanted to follow up on Representative Poirier's question. So am I right in understanding that there are no fixed standards, qualifications, or training requirements for visitors?
I'm just looking at the appointment of a visitor because I know there are some. There are some. Yeah, there are none. There are none. It says the visitor must be an individual having training or experience with the type of abilities, limitations, and needs of the alleged person in the petition. That's our standards.
Can I ask just one follow-up question?
Yes, go ahead.
And I'm sure this is going to be very anecdotal, but just I'm curious to know if you have ever worked with visitors who are disabled themselves.
I have not. I have not. I think mostly we're using medical professionals, and but we do. Like I said, we have 2 retired social workers that have disabled children, adult children themselves. And so we do recruit people, you know, for specialized situations.
Understood. Thank you.
Thank you very much. Now I am not up. Representative Sheehan, are you all set with your questions, or did you have another one?
Yes, thanks.
Okay, not seeing any additional questions for Ms. Ayers. Thank you very much for being here today and providing all of this information. We may ask you to come back to us for the work session and may reach out to you with some information requests as well.
No problem.
Thank you.
Thank you.
And now I'm looking at the the attendee list. Is there anyone else who wishes to speak in opposition to this legislation? Not seeing any virtual hands. Is there anyone who is an attendee who wishes to speak neither for nor against? And again, I am not seeing any. And so that closes the hearing on LD 480. And I don't have a gavel, but we'll declare the hearing closed and move on to our second public hearing of the morning. And that is LD 402. And it is being presented today by Representative White, who is just traveling through cyberspace to join us. And Representative White, once you're in, you can activate your video and audio and present your bill.
There we go. Thank you.
Thank you. Welcome very much to the Judiciary Committee.
Yes, and I have a new appreciation of your committee work.
We
I've
just
been
lost your
listening in.
video, Mr. White, Representative White. Could you activate it again? Thanks. There you go.
Okay, so give me 1 second because I had my testimony and I put it in. That's interesting. Sorry about that. So if I do this, you lose my video?
We do.
Okay, that's interesting. You know how technology is?
Yeah, do you need to have your testimony up on your screen? Because we can do that and then you can reappear for questions.
I'm good. I think I'll be all set. Okay. So thank you. And thanks to everybody for letting me testify. And thank you. Good morning, Senator Carney, Representative Harnett, my old seatmate, and members of the Judiciary Committee. I'm Representative Bruce White, and I represent part of Waterville. I'm here today to introduce LD 402, an act to protect an individual's personal data. This is a very simple piece of legislation that allows a person immunized or vaccinated in the state to forbid the state to disseminate any personally identifying information collected by the state as part of that immunization or vaccination to any third party, including the federal government. I submitted this legislation after learning about reports that the federal government was seeking from states personal information regarding who was receiving COVID-19 vaccinations. States were informed that the federal government was interested in the names, birth dates, and addresses of vaccine recipients. Personal health information, such as what vaccines you have received, are just that, personal information. An entity that holds that information should not be able to provide it to anyone else without a patient's explicit permission. The state's ability to access this information and provide it in a de-identified aggregate manner has been very useful in making specific public health decisions, such as when to add new groups to the vaccination schedule. This information has been and continues to be provided to the public and, of course, the federal government, and allows us to show everyone where we are in our vaccine rollout. Providing individualized information to third parties will not improve our response to the virus and does not seem to serve a needed health concern, needed public health concern. In short, there seems to be no good reason to provide personally identifying information without explicit consent. When reports of this practice first surfaced, the reason given was to be able to chase individuals who may have missed their second shot. Setting aside that, there seems to be no reports of widespread cases of individuals not showing up for a second shot. The federal government has actually taken no active role in the vaccination of individuals beyond getting bulk shipments to the states. Any follow-up for missed shots should be at the local provider and state level, and there is no need or reason for any of this information to be passed to any third party, including the federal government. I urge the committee to ensure that individuals' information regarding vaccines remains private, and that we ensure that the state is not put in the position of becoming a data mining operation for any third party with regards to patient information. Thank you for your consideration. Sincerely, Bruce.
Thank you very much, Representative White. I see that we have a couple of questions already, and we'll start with Representative Harnett. We're not able to hear you, Representative Harnett. Thank you.
To quote my good friend, Representative Moriarty, of course not, because this is what happens with the muting button. Thank you, Madam Chair, and very nice to see you again, Representative White. Miss our morning conversations in the back row. I'm curious, do you know if the information that you're seeking to protect here is already confidential under state law?
Well, under the HIPAA laws, possibly.
Well, the federal law is HIPAA, but the state counterpart.
Yeah, I don't know. I have asked, actually the AG's office and somebody at DHHS if we have signed on to this, and I haven't really heard anything specifically on that.
That's information I would certainly like for the work session, because I'm just not certain that the bill, if the bill's not needed, I don't want to enact a bill that is not necessary. So I guess I would ask the analyst, Peggy, if we can determine if this type of personal information is already confidential under Maine state law.
And my understanding too, is there was an article that I can send out, and back in December, that what the federal government was asking for, and I believe some states were signing on, but actually not sending the data, and other states were not even signing on. So it seems a little confusing, and any info we can get for the work session obviously would be very helpful.
Yeah, we do have an indication that we'll have that information available for the work session, because I think that's an important piece of the puzzle here. Did you have a follow-up question, Representative Harnett?
I did not, Madam Chair. Thank you very much.
Representative Reckitt, go ahead.
Thank you. When I, where did I go? Oh, there I am. I think there's going to be a new optical disease called Zoom fatigue by the time we get done this session. My eyes are killing me. The question that sprang to mind when I read the bill this morning, two questions really, but both of them connected with international travel, oddly enough. And it may be just a concern out of nowhere for me, but I'm concerned that it might be that there would be a reason for the federal government to know whether or not, if you have a passport or want a passport or apply for a passport or a visa or something, that you in fact are safe to travel, not just for yourself, but for the people you're going to see when you travel. And I'm particularly concerned about travel to Canada. But I I have no idea if there's any impact around this but that's what the question that sprung to my mind when I read the bill today. So if you have any insight on that, I would be thrilled to hear it.
Right. I don't, but I'm just like, where do we draw the line? You know, what information are we going to allow them to have about us, and what information not? So I think it's a very slippery slope in some ways. So, but I understand they need certain information that, you know, which can be without using specifics, I think.
Yeah, I mean to interrupt you, but I mean, I don't, I agree with you. It'd be lovely if you didn't share anything that is, you know, personal on some level. But to me, it's almost like the analogy that I keep popping into my head is that there is a whole, you know, no-fly list for terrorists. You know, I'd like to be a yes, go list for those who are fully vaccinated. I mean, I don't know. I mean, it's probably just crazy, but I'm really, that's where my head went when I looked at this. So I'll be quiet now and hope that somebody has some idea about this.
Yeah, we'll get that information. We'll look into that for the work session too, to see if there's information related to international travel. Thanks for bringing that point up. Representative Libby?
Thank you, Madam Chair, and thank you for being here today, Representative White. My question is, as I'm thinking about this bill, I wonder if you have any concern that if folks knew that their private identifying information was leaving the state and was going to the federal government, if there might be any issue with a reluctance to get the vaccine that folks would otherwise be willing to get, you know, if that could impact that.
Thank you, Representative Libby, because that is exactly one of the major concerns. I think that if people feel that their personal information is being shared, they will be more reluctant. And we, of course, want people to feel free about having not only the COVID vaccination, but other ones that they, you know, that might be necessary or good to have. So I think that is very critical point.
Thank you.
Representative White, I have a question for you. Can you give us more information about the source of the report that this information was being shared?
Yes, it was actually an article in the New York Times, which a constituent of mine sent to me. And I actually just printed that out I've had it, but printed it. And I have the link to that, so I could send that off to you.
Thank you.
Okay.
Thank you. It looks like Representative Harnett has a question.
It is attached to the testimony of the individual who contacted Representative White.
Okay, great. So perhaps it is time to turn to others who wish to speak in support of this legislation. Are there any other questions for Representative White? Not seeing any. Thank you very much, Representative White, for presenting your bill today.
Well, thank you. And, you know, I heard it could be intimidating coming before your group, but I don't feel that in any way. So thank you.
We're glad you're here.
Yeah.
And I see we have in the attendee section of this meeting, is it pronounced Ryan Finch? Is that the correct? And are you here to testify in support of this legislation? If so, please raise your hand. Terrific. We are going to move you into the panel, and welcome, Mr. Finch.
Hello. It's Rian.
Rian, okay.
Yes. It's pronounced the opposite of how it's spelled. But thank you. Thank you for allowing me to testify. So I read this article in the New York Times. I attached it to my testimony. And I'm not going to read my entire testimony. You guys have it in front of you. But But I do just want to highlight, that one of the biggest concerns that I have is that the federal CDC has essentially said, the federal government has said that they don't have a system in place to protect this data. And which literally just means it's essentially the same thing as putting it on the internet. If you don't have anything in place to encrypt and protect this data, then anybody can get at it and get to it. And I think that should just be the automatic deal breaker. But then aside from that security concern, even if the federal government did have, a system in place to encrypt and protect this data, they don't have a need to automatically get everybody's data. One of the reps had asked Representative White about international travel or getting a passport. There's a difference between requiring people who are leaving the country to prove that they have a vaccine, or airlines asking you to provide a proof of the vaccine, versus automatically putting people who never have the intent of even leaving the state for the federal government to have this information, which is also why I would like the committee to consider amending this to just flat out opt the state out of sending the data, instead of right now where it's opt in. Essentially, somebody has to individually know to contact the state to opt them out. I think just flat out not providing the state with the data. I did look through numerous state statutes and couldn't find one that explicitly said that any Mainer's personal identifying information is prohibited, is protected and will not be sent to the federal government. And there may be a difference between third party and federal government. I mean, the way that this is written right now, it says including the federal government. And so I'm not sure kind of in terms of governmental sharing of information, if there's anything in state statutes that would protect personal health information from being sent. And I'll just stop there. And if anybody has any questions.
Thank you very much. You came in right under our 3-minute testimony limit, and I believe there are going to be some questions for you. So hang on just a moment. Representative Moriarty, go ahead.
Thank you, Madam Chair. Mr. Pinch, I have been reading the article attached to your testimony. It's from early December from the New York Times, and apparently the then administration required states to submit data, but the article reports that some states, New York among them, were pushing back, either refusing to sign at all or refusing to share data. So we've all been struggling with the question of whether Maine has signed anything or is in fact providing information. Do you have any insight on that question?
So I know that Maine has signed an initial agreement for the initial batches of vaccines that have come. I have been unable, along with Representative White, unable to get an answer from DHHS about what that agreement for the vaccines looked like and what it contained. And then I was also able to find out from DHHS that as of early February, the state was still negotiating for another round of vaccines, and included in those discussions were discussions about what, if any, personal information to send. That was back in early February. I do not know if an agreement has been signed and what that agreement contains.
Thank you then.
Thank you, Representative Moriarty. Are there other questions? Not seeing any other questions from members of the committee. Thank you very much, Rian, for presenting your statement today and for answering all of our questions. At this point, I'm looking at the attendee list, and asking if there's any other attendee who is here to testify in support of LD 402, please raise your virtual hand. And is there anyone wishing to testify in opposition to LD 402? If that's the case, please raise your virtual hand. I see Representative Harnett, you've raised your hand. Do you wish to testify in opposition?
No, I do not. I can wait till you've gone through the list. I just have a request for the work session.
Okay, we'll take requests in just a moment. So I'm not seeing anyone asking to speak in opposition. Is there anyone here to speak neither for nor against LD 402? And again, I am not seeing anyone who wishes to speak neither for nor against. So at this point, I'll declare the public hearing on LD 402 concluded and closed. And now we will move on to a committee suggestions for information that we would like available for the work session. And Tom, you have the floor.
Thank you, Madam Chair. I would just request that we have somebody from the Maine CDC or the Department of Health and Human Services come to the work session so that we know, one, what we are doing, what we plan on doing, what we're being asked to do by the current administration. And again, I'm just trying to determine, I understand the reasoning behind the LD. I just want to confirm that it's necessary. That's all.
Thank you. Committee members, are there other requests for information for the work session on this bill? Great. I'm not seeing any additional ones. Please let Tom or I know if you have other requests after we conclude. And then I did want to turn to one thing that yesterday, Peggy and I, our analysts, decided we would do this first thing in the morning, and I, of course, promptly forgot it. But we have a language review on LD 145. Peggy, are you able to take that up now, or do you want to take it up this afternoon?
Either way, if I don't know if you have that document in front of you, or I can share my screen if I can remember where I actually saved it.
Mm-hmm.
Yeah, if you want to, so just the process is nothing goes out of the committee until you have seen it. If it's an amendment, just to make sure that it's definitely something here. I've got it. I can share it in a minute. It's your amendment. I want to make sure that it's exactly what you want it to say. And if I can share it on the screen if you'd like.
Yes, I think that would be helpful. Thank you.
Whoops. Is that, do you see my?
Yes, perfect.
Yes, okay. Where's my cursor? Okay, so this is LD 45, and you voted to add one more section. This was about the Uniform Probate Code making some changes, and one of those changes was extending the effective date for some confidentiality provisions. The whole idea is for the court to adopt rules that govern confidentiality of records in the probate courts. They are working on those. Kathy Ayers actually this morning told me that they have drafts that are out for circulation. So it's in process, but just to make sure, one of the things the bill does is extend that effective date from January 1st, 2021 to January 1st, 2023. And they left out a provision. The bill addresses guardianships and conservatorships, but what it didn't address is something called protective arrangements, which are things less than a guardianship. It may be to help somebody enter into a transaction to sell their house rather than a whole guardianship. And so the recommendation was to amend the bill to add in this one section, and that's what this section 6 is here. Let's see, can I highlight? Oh, I can almost highlight it. So this is the change that's going into the bill. And that's a brand new section to the bill. But what this bill is also doing is it's amending the emergency preamble. The emergency preamble is necessary to explain why the legislature thinks this should happen faster than 90 days after the legislature adjourns. It mentions conservatorships and guardianships, and we're adding in right here other protective arrangements. So the amendment is amending the emergency preamble in 2 places, and then we're actually adding statutory text. And then in addition to that, because we're making those sections take effect retroactively to January 1st, when this was originally supposed to happen, we're amending the effective date clause. And so the effective date clause says these sections that amend the probate code really take effect January 1st of 2021. And what we're doing is inserting a reference to this 511, section 5511, subsection 4. So little amendment doing lots of things, and there's no way you would really understand all that just looking at this piece of paper. And so this is what the bill looks like, and this is what the amendment will do. On lines 5 and 6, it's going to cross out the and add in and other protective proceedings in the emergency preamble. This is all the bill that you've already voted on. No more changes until we get to here, where that new section to the bill is added to put in the new effective date of 2023. And then we're amending the retroactivity clause to add in section 5511, takes effect retroactively to January 1st. Now, I know I ran through that really, really, really fast. If you have any questions, you certainly ask me. And one of the things I put at the top of this is there is no fiscal note required. Everything goes through the Office of Fiscal and Program Review, and they review it, and they review it for cost to the state. But they also do an analysis of whether they think it's a local government mandate. And they have identified no costs that would be associated with this.
Thank you, Peggy. To me, that sounds like exactly what we discussed in the work session on this bill. I have a question for you, which is if we approve this language change, is this one of the bills that could go forward when the House and Senate meet on March 10th and 11th?
Yes, and actually what I've brought you is the final version of the language. If you wanted to make changes, then obviously it wouldn't be final. But this is ready for the revisor's office to sign off, and then it could be reported out. And I think the deadline is like tomorrow morning to get it out of committee. I'm assuming everybody has voted on this bill, and Soupy's not looking for any votes that had to be registered through the speaker or the president. And actually, I think the 2 business days have expired. So. So this should be on the calendar for the House calendar on Wednesday. Is that when you meet? Yeah, Wednesday.
Yep. Thank you. Representative Harnett?
Thank you, Madam Chair. And I just want to point out that this is even more important because it is an emergency bill, and the emergency legislation can go into effect immediately rather than waiting till the next time that we come back into session. So there's a sense of urgency here.
Right. And with an emergency, we'll take a 2/3 vote of each body.
Do committee members have any questions either about this process in general or about this process as applied to this particular piece of legislation? Not seeing any hands raised. Are we required to do a vote on this, or do we just indicate that it's acceptable? Because we've already voted on it.
Right. You've already voted on it. You would only need to vote if you decided you needed to change something. And we recognize that it was a substantive change rather than a technical change. And you say, oh, now that we see it, we think that it really should be 2025. That would be a substantive change, and then you'd have to revote that.
Okay. So does anybody have any changes that they would like to propose? Not seeing any indications. That's great. So it's wonderful that we were able to do the language review. Thanks for all your work to get that to us in a super speedy way so that it can proceed on to the House and Senate for consideration as an emergency.
Good.
And with that, I think we are done our work for this morning. We'll reconvene for a number of work sessions at 1 p.m. this afternoon. And Judiciary Dems, look for a text message from me about some scheduling issues. And I think that we're all set. Please remember to either log off or turn off your video and audio while we are on our lunch break. Thank you, everyone.
Thank you.
Hey, gang, are our microphones on?
Yes,
Okay. Then I won't say anything inappropriate.
right. You would never say anything inappropriate, I'm sure.
You should see me at home. She puts up with me, so what am I gonna say?
Jeff, you said you were going to do some outside work this weekend. I'm going to have to pick your brain. We moved this past fall from a quarter of an acre to 7 acres, and we are novices at all things outside.
Yep. Well,
We'll
you
have to
burn
chat
wood?
sometime.
You burn wood?
We don't burn wood, but I think we're going to be doing some probably kitchen renovations this year that will include installing a wood stove.
Yep.
And so I think we are going to plan to burn wood, and the majority of our property is woods, but it's woods that have been pretty long neglected. I think there's a lot of very old, very tall growth, and there's nothing small in our woods. It can't grow because
you have hardwood trees?
we have some. We have it's very pine dense.
Yep. Well, you just have to, your husband will have to get a chainsaw.
He's very excited about that.
Yeah, and just first of all, first thing you do is go along your forest floor, and anything that's dead on the ground and still solid is, you're going to be cleaning up your land anyway, so it's free wood there. And then oak and cherry in particular, if they're dead and have been laying on the ground for 20 years, it's still good. It won't rot. Where birch and maple will rot in 2 years.
Yeah.
So you'll have a lot of fun. And you have some open fields too.
We don't really have open fields. I would be terrible at estimating amounts of acreage, but I would guess that our open yard area is probably somewhere around an acre.
Yep. Well, that's plenty.
Yes.
You're gonna have a garden?
Yes, we will have a garden.
Yep.
But we also are trying to figure out where that will go because our trees it's like a U shape around.
Yeah.
So we will have to figure out where we can get sunshine.
12-hour sunshine, so you might have to drop a couple trees.
I think so.
But just pick the best spot you can in the sunniest location. Find the local dairy farmer so you can get a load of cow stuff. And,
yes.
And then either have people come till it for you or sell for a small tiller. I think Troy-Bilt now sells a $600 tiller.
Really?
That works pretty good. It's not the kind I have. I bought it in 1978. It's still works. That I paid $980 for it. It's over $3,000 now. But this $600 one, once somebody comes in and breaks the ground up for you once, the $600 one will take care of it forever.
Oh, very nice.
And it's like a lawnmower almost. It's got that handle that you squeeze. So even not that women couldn't do the heavier one, but it is heavy, hard. But the $600 one, anybody can use it. My neighbor had.
That's great.
Yeah, you'll have a lot of fun.
Yes.
That's what I go out. I'm in my wood cutting mode right now. So.
Oh, fun.
But I've got probably 2 years supply, but I've got to find things to get exercise with. So. Because my wife wants me to paint inside the house in places, but I'm too busy.
Yes.
It's coming, but that comes in June when we adjourn, then I'll have the time. It's hard right now.
Yeah.
Everyone's schedule's a mess.
Well, thank you for your tips.
Yeah, you'll have fun. And the first, you have is it all lawn, your open area, or is it a lawn? Or?
Open area is lawn. The folks who owned it prior to us did quite a fair amount of landscaping. And I don't know that we'll keep it all because our kids really like to have, really pretty open areas for playing soccer or baseball or whatever. Yeah. So I think we probably will rearrange some of the landscaping and put some of the flowers closer to the woods so we can still enjoy them, but not have them right in the middle.
Well, don't do what my mother did when I was 10 years old. She put her green bean patch right on the first baseline of our That didn't work out too well for the beans.
No, I'm sure not.
She used to come out screaming at us, and I'm going, Mom, it's, how can you run to first base? You put the beans in, So she lost that one.
Well, you lost the beans.
Yeah. Matter. There was a farm stand locally, and I worked with that since I was 10 years old. So
nice.
So I learned a lot of agricultural skills. I try to grow almost all my own food.
That's amazing.
I don't raise. I used to raise a head of beef every year too, but I don't.
Mm-hmm.
I've got a cow, but it's
Nice.
she was too friendly, and I bought her when she was 3 days old at the Skowhegan
Oh.
agricultural auction. And she just bonded like a dog, and she's so smart. So she's 10 now.
Wow.
It's a pet, but she keeps 4 acres of my field clear. I don't have to have a bush hog or anything. She looks like a
Nice.
golf course the way she eats it down.
Wow.
So yeah, we named her, and she was friendly. You call her, she'd be 600 feet away, and you call her, she'll come running to you.
Oh my goodness.
It's funny.
Wow.
Well, you'll enjoy that, and
We will.
and the kids will enjoy the space to play. They like sports.
Oh yes.
Yeah, it's the best thing. It's a lot of fun.
Absolutely.
How many kids do you have?
We have 4 at home.
Yeah, wow.
Yep.
Boys and girls?
Yes.
Yeah. Nice.
Nice. But nobody at home.
Yeah, we're old, Chris. Our kids are gone. Our grandkids. I'm working on them now.
You have reminded me of that a few times, Jeff.
That's the second time this year. You asked for the first one.
I must be getting sensitive to my old age.
Well, welcome back, everyone. Sorry for the delay in reconvening. This is the Joint Standing Committee on the Judiciary. We're here today to do actually quite a large number of work sessions. We've got 8 work sessions, and we are going to start with LD 222. I will ask committee members, does anybody feel the need to do another round of introductions? We did introductions this morning. Everybody okay with just diving back in? Okay, we will do that then. And we have our committee analyst, Peggy Wrench, here, who is going to lead us through the work sessions, and our committee clerk, Susan Panett, who will be taking the roll call votes on our bills. And welcome, Peggy and Soupy. And let's see, so we'll start with LD 222. This is a bill that we began discussing at our most recent work session, and we just frankly ran out of time on it. And so I would like us to continue to discuss it. Peggy, do you have a reminder, I should know this, of where we were at the time?
Well, there are 2 main parts of this bill. One is the voluntary acknowledgement of parentage. And I think you had worked through that so you understand what it is and what it does for the most part. But I think some people had some questions about the effect, and you do have a couple of people in the attendee list who would be happy to answer those questions if you want to bring them in. And then the second piece of the bill is about the obligation to collect information by sperm banks and gamete banks and fertility clinics, and then share that information. Some of it has to be shared if they have it, and the personally identifying information can only be shared if the person who gave them that information authorizes that. So 2 big different parts in this bill.
Thanks. That's a great overview. And I'll take a check in with committee members about where we are now. When we stopped our work session previously, we were on the second issue, but I do want to be sensitive to the fact that committee members may have questions initially about the voluntary acknowledgement of parentage section. Is there anyone who has, well, before I get to that, Representative Libby, did you have a question?
And I am not sure if this is the appropriate time, so I'll just put my question to you. When we were closing, Ms. Willis had indicated that switching the wording in the first section from back to the woman who gives birth to a child was acceptable. And so I was wondering at what point it would be appropriate to address that.
Are you thinking that you'd like to make a motion to amend?
I am thinking that. Thank you.
Okay.
Thank you, Chair.
Sure. So I think that let's check in and see where we are. The motion to amend would come after we finish having a discussion with and having additional questions answered. And I will not forget, but please remind me. And Peggy, do you agree that that is the correct way to proceed?
Sure. I mean, I've seen committees do all sorts of things. That might make a motion initially and then discuss it. So however you're most comfortable working through it is the main thing.
Okay.
Get the discussion out there.
Great, thank you. Okay, so let's just continue to do the check-in. In addition to Representative Libby wanting to propose an amendment with regard to the voluntary acknowledgement of parentage issue, do committee members feel the need to obtain additional information, just obtaining information about that section? Not seeing any. So let's move on now. This is just with regard to requesting additional information. The second issue has to do with collecting information and confidentiality with regard to gamete donors and fertility clinics and that sort of thing. Are there committee members who have additional questions with regard to that issue and aspect of the bill? Representative Moriarty?
Thank you, Madam Chair. A question for Peggy. Is subchapter 9 part of the legislation drafted by the Uniform Law Commission 4 years ago?
Yes, it did not exist when when FLAC did the original Maine Parentage Act, if I remember correctly, and this has been added in the most recent version by the Uniform Law Commissioners.
Okay, I wasn't sure whether this was a homegrown or came from the Uniform Commission.
Definitely came from the Uniform Law Commissioners, but FLAC worked through it and made sure it was still consistent with the Maine Parentage Act.
Yes. Okay, good. Thank you.
Are there other questions in addition to questions for Peggy? We do have in the available as attendees to whom we could ask questions. Debbie Willis from the AG's office, who spoke to us earlier, and also Mary Bonato, who was kind of in the midst of talking to us when we ran out of time. So do committee members have questions that they would like us to pull those attendees into the discussion space? Representative Libby?
Thank you. As far as the collection of information, I'm still struggling with this piece of it that I understand the intention behind the data collection completely, and that seems very benign. My concern is that if this information is being mandated to be kept for whatever amount of time, that there could be a use in the future, whether it's a grown child deciding they want more medical information, and so that they want information that donor had not planned to give. That's my concern. So I'd just like to know how likely this is to be open to any kind of suit or anything in the future for that purpose.
So it sounds like it's appropriate for us to bring in Mary Bonato and Deborah. And so we're going to go ahead and do that. Debbie Willis. And I think that I have not been empowered to move people through cyberspace. Supi, could you please move Debbie Willis and Mary Bonato into the panel?
I got him.
Thank you. And we also have the bill sponsor here as well. Okay, so let's ask this question of Mary Bonato. Mary, were you able to hear the concern that Representative Libby raised? Could you address that, please? Yeah.
Thank you.
Rick?
Good afternoon, everyone. I can certainly try, but I would also be very happy right off the bat to defer to the sponsor as well as Debbie Willis if they would like to speak first.
Representative Cardone, would you like to address this issue initially? I'm not seeing her currently in the meeting. Go ahead, Ms. Willis, would you like to address it?
I can, along with Mary. What I would say, Representative Libby, is this is not changing current practice. This is a good practice for the clinics, and this is what they are doing. And within the statute, and this is HIPAA information. This is medical information. We're calling it a donor, information about the donor, Representative Libby, but it really is medical. This is just like anybody's medical information. And there's limits as to what they can get within the statute. So I don't see it as a concern that, I'm assuming that if you're donating your material here, there's an expectation that a child is going to result from that, and that child might want medical information. And I believe that that's what's available.
Okay, I guess my question then would be if it's good practice and standard practice. I think Representative Harnett had brought up on a previous bill, do we need it? So that I guess that's kind of my question on this part. If this is what they're doing and this is good practice and standard practice, then why do we need to put it into statute?
I wish Mary could speak to that because she has more experience with the clinics.
Yeah, yes, Ms. Bonato, could you please address that aspect?
Thank you, Senator.
I can try. I think it's a fair question. Generally it'd be awesome if everybody followed the best practices in their industries, whatever that industry or profession may be. It doesn't always happen. And so having a statute in place that, again, we'll also note there's language in the bill about best efforts and so on. So I think that reduces the likelihood of litigation. But so it's there as I think perhaps as a belt and suspenders and putting this, when you have a law, you also give notice to the world, right? Including those people who have used assisted reproduction and to their children that this exists. And there may be an opportunity for you, A, to find out medical information during the child's minority, should you need it. And then B, if a donor has agreed to be identified after the child turns 18 or whatever that may be, when the child's 40, that they would be able to attempt to attain that information. So laws have those functions of trying to actually, I think personally, of trying to ensure that conformity with best practices. And this is consistent with best practices, which, as I stated last time, the American Society of Reproductive Medicine actually recommends keeping this permanently. Of course, it doesn't mean you're going to be in business permanently. So that's one thing. But then also just giving notice to those people who are the consumers here. I also did ascertain between our last meeting and this one that there's really only one entity currently in Maine that would perhaps qualify as a bank, and it's Boston IVF that operates, it's Boston IVF Portland, that apparently does collect and store on premises sperm and eggs. I don't know for how long. And then other than that, there are, plenty of, people in, who practice reproductive medicine who are using, donated gametes in their practices. But there's really only one bank, if that's any help.
I have a question, Ms. Bonato, related to kind of best practices and ensuring standardization. So this second section of this legislation is based on, uniform legislation. Is that correct?
Yes, it's drawn from the 2017 version of the Uniform Parentage Act, which is building out on Maine's.
And so by adopting this, not only would we ensure meeting the best, highest standards here in Maine, but we would align what's happening here in Maine with what's happening in other parts of the country.
Well, that is actually an excellent point, if I may say, because one of the values of these uniform laws is that it allows you to be able to benefit from the experience of other states and how they are interpreted things, so that if there is any question here in Maine about what we should be doing, whether the provisions should change legislatively, or to Representative Libby's concern, should there be litigation and how to actually think through the problems, there is a greater sort of experience bank, if you will, upon which to draw.
And there's more consistency for us pesky people who tend to kind of move from state to state throughout our lives, potentially, that somebody who was in Maine as a 18-year-old or say as a 14-year-old might be in Michigan as an adult. And if we have some kind of more national standard, that just gives people predictability regardless of where they live.
Well stated.
Yeah. Other committee members have questions? I see that the bill sponsor is here, and she was unable to be with us because of scheduling issues initially. So I would like to give Representative Cardone a moment to offer any additional observations she has.
I don't think I have any additional observations. I would be happy to answer questions if someone has them, but I don't have anything that I need to add.
Thank you. I'm now looking to committee members. We are kind of moving toward a motion to amend and a vote on this bill, LD 222. So are there additional questions that anybody would like to ask of Ms. Willis or Ms. Bonato or our sponsor, the bill sponsor? Okay, thank you very much. At this time, I think we will move you back into the attendee space. We appreciate.
Senator Carney, could I say one
Yeah.
thing before I go back into attendee? Because I
Yes,
did.
but before you do, let me just see if Representative Harnett had a question.
Thank you, Madam Chair. And it's a question to both Mary and to Mary Bonato and Debbie Willis about the original issue that was raised by Representative Libby today, and that's about subchapter 3 with the voluntary acknowledgement of parentage and the use of the phrase person who gave birth 6 times. I think it's used 6 times in that section. And there was a discussion of changing person to woman who gave birth. And I wanted to hear from the bill's sponsor and also Ms. Willis and Ms. Bonato, if she'd want to weigh in. Is that a change that you would be supportive of in an effort to get this entire piece of legislation moving forward?
Was that addressed to me? I'm sorry.
It's addressed to you, Ms.
Yeah.
Willis and Ms. Bonato.
I'll call on, just to maintain the process, I'll call on people. That's a great question. Thank you. We'll start with the bill sponsor, Representative Cardone. Could you respond, please?
That is not that's not a proposal that I would be in favor of, an amendment that I would be in favor of, because it does exclude a small but a class of people who would otherwise fall under this. It is entirely possible that there would be a person with a uterus who may not identify as female, who would give birth, and that is that person would fall under this statute. It is not limited to women. In our attempt to be more encompassing and more sensitive about not only gender equality, but the way that we gender neutral in the way that we use language in our statutes. I think it also is important to keep the word person and not include the word woman. That's my opinion.
May I have a follow-up there?
Yes.
Thank you, Representative Cardone. And my concern is words are powerful things. We recognize in the state of Maine non-binary persons. We recognize in the state of Maine transgender persons. So there are instances in which a transgender person who does not identify as a woman or a non-binary person who does not identify as a woman could give birth. We also have a statutory rule of construction that pretty much writes out gender, even when we use gender-based terms. So I am concerned about the power of that word because it writes people out of the law. They do not see themselves in the law. My question was, and maybe it's an unfair or impossible question to answer, but is there room for a compromise here to get the bill through and deal with these issues at a later time? It's not something I'm comfortable with, but I do see this as a very important act in its entirety. So, you know, we always have a much better chance of enacting legislation when it's unanimous coming out of committee. So I just put that out there, and I don't know if there are answers to those questions.
My opinion would be that I agree with you. It's an important statement to keep that word gender neutral for all the reasons that you've just articulated. I think it's more important to stand on that principle than to have than to avoid a divided report. And I strongly suspect that even if you come out with a divided report, that the legislation will pass.
Thank you, and thank you, Madam Chair.
Yeah, and at this point, I'm going to circle back to Debbie Willis and then to Mary Bonato for their answers to Representative Harnet's questions. And then I will take the committee members who have raised hands. Ms. Willis, you can proceed.
Thank you, Senator Carney. And just a reminder that FLAC didn't introduce this bill, but FLAC worked on the text for the judiciary for this. So anyway, I heard Senator Kiam's concerns. I took those concerns back to FLAC and I met with them about a compromise that I just heard Representative Harnet talk about. So I wrote this in words. So let me say this, that although, you know, FLAC strongly supports the bill and believes it makes important changes, and although it makes sense to FLAC to change to person who giving birth to be consistent with the overall policy for the statutes to be gender neutral, and that the change addresses the need to be inclusive of all those individuals and parents who aren't described by the traditional nomenclature. FLAC still believes the other changes are important enough to go forward without the gender neutral language, if that is a finding of the Judiciary Committee. And yes, I too seek a unanimous report out of the Judiciary Committee, but that's the Debbie Willis speaking. So that is what FLAC had to say. And thank you for letting me get that in, Senator Carney.
Sure. Thank you very much. Ms. Bonato?
Thank you. From GLAAD's perspective, this is a very, very important bill because it is protective of children and establishing their parental relationships as soon as possible. And really just key to people's security and family stability. So it is with a heavier heart that we make this change, although I would recognize that the Maine Parentage Act as a whole uses the term woman giving birth, as does the Uniform Parentage Act of 2017. So it is consistent with those. However, there are going to be people who our state values and respects, who are giving birth, who do not identify as women. And I hear Representative Harnett's statements on that, and I agree with them. So it may be something to return to another day. As I was sitting here, I have to admit I did think of something else that I'm not making an amendment, I know I can't. But I would wonder if it would be possible, since there are going to be people giving birth who need the same security for their families and for their children, if it would be possible to consider something along the lines of a woman giving birth and any other person giving birth, so that they all have that security. But in any event, like others, we think it's extremely important to pass this bill.
Thank you all for your thoughts on those issues. Very important to hear from all of you. Representative Reckitt, you have the floor.
As much as I hate to admit that I periodically manage to squeeze in an hour or two of commercial television, I don't know whether this week anybody else saw the show, and I think it was New Amsterdam, but it might have been one of the other doctor shows, where a person was giving birth who was not, in fact, a woman. And so it was the first time I had really thought it through in my own head. And it was a useful exercise for me to do that, because I had not spent enough time, I think, even though for many years when I was teaching human biology, I was teaching about surrogacy back before it was happening very much. And actually talking about the ethics of surrogacy. And I think that this is all tangled up in that. And although I was willing an hour ago to consider the substitution of woman in order to get a vigorous vote on this bill, this minute I'm not, because I think there are too many communities that will be hurt, even if not physically or in this particular instance, but emotionally, that we would then do what feels like a retreat from some of the ways that the legislature has been moving in the last 2 years and last 4 years, and recognizing that there are now, to my knowledge, and there may be more, there's 7 LGBT people in the House of Representatives in this legislature right now. And to me, it's sort of a slap in the face. And I don't want to do that. And so I'm probably not willing to go along with that. But I could also be talked out of almost anything in my life. So feel free to try. But at the moment, I'm feeling like I want to leave the word parent. Is it parent? No, person.
Person.
Person. And it was a P word. Leave the word person in there. But as I said, I'm not totally immobile, but that's my opinion at the moment.
Thank you, Representative Reckitt. I feel like just from a procedural perspective, if we don't have additional questions and comments from Ms. Bonato and Ms. Willis, that we should return them to attendee status and continue our discussion on the bill as a committee. So we'll do that. And I rely on Peggy or Soupy if they can accomplish that. Thank you. And we'll keep the bill sponsor here. I think that it's appropriate to have her here. At this point, I recognize Representative Libby.
Thank you, Madam Chair. In discussion of the bill, I would like to say that, as I see it, in an attempt to be inclusive, we are actually excluding, minimizing, and diminishing women. And so I understand the concern for the emotions of some, but if you would like to consider the emotions of all, that is a very large pool of women that we are excluding, minimizing, and diminishing. I feel very strongly about including the woman, the term woman versus person in this bill. And we've talked a lot about conformity to the exact word, the uniform the uniformity in these bills, and that is uniform. So I would advocate strongly for keeping the word woman in the Uniform Act.
Representative Libby, could I ask you a question?
Yes.
How would you feel about the language, a woman who gives birth or any other person who gives birth? So including both phrases.
I could not vote for that. If a person doesn't identify as a woman and is giving birth, what are they? Personally, you either have a uterus or you don't. And that's what it comes down to for me. I understand that is not everyone's opinion, thoughts, or feelings, but to me, the language should be woman. Thank you, Madam Chair.
Thank you for answering my question. Representative Sheehan?
What about language like a person with a uterus who gives birth?
Is that a question to Representative Libby?
Yeah, I just think I'm putting it out there
For
in general, since the consideration is the uterus.
Okay.
May I answer?
Yes, and then we'll go to Representative.
I appreciate the suggestion from Representative Sheehan, and I would need time to consider it. And when the time is appropriate, I would move to table this until my leads can also be present.
Representative Poirier?
Thank you, Madam Chair. I was just going to just throw it out there. I know that the concern right now is the language on the bill and trying to get a consensus with the whole committee. But my issue with the bill isn't actually just the language on that portion. So I don't think it's going to be a unanimous across the board anyway. So I'm not sure that us hashing out just the language is going to have a huge impact on the vote. So I'm not sure if we should even spend a lengthy amount of time working on the language. That's just my opinion. I wanted to throw that out there.
Thank you for letting us know. Are there other committee members who have comments or suggestions regarding the bill before we start to move toward a vote? Not seeing any hands. And I understand, oh, Representative Harnett. And there you go.
I was ahead of myself. I apologize.
Okay. Any questions or additional comments on parts of committee members? Not seeing. Yes, Representative Libby and then Representative Babbage.
Thank you, Madam Chair. I move to table until my leads can be present.
This is where my inexperience as a committee chair is coming to the foreground. The proceeding on a motion to table, I believe, is non-debatable. Is that correct? We do not have a second at this point. I'm seeing a second by Representative Poirier, and we will move on to a vote. So all those in favor of the motion to table LD 222, please signify by, let's do it with the
Show of hands.
show of hands. Let's do that. Those in favor of tabling, please raise your hand.
Oh, yeah.
I actually
count.
would like to, I'm also in agreement with tabling, actually.
Okay, I see 6.
Those opposed?
1, 2, 3, 4. Am I not counting somebody? Is that what you have?
I think that's, let me just see, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Yeah, that, no, there are 11 of us. Okay, let's revote. All those in, and I'm going to change my vote, I think. All those in favor of,
Madam Chair, may I explain my vote, if I may? I just feel as, unless there's a specific deadline that needs to be made, that we usually traditionally honor a member's request for more time. That's as a courtesy, not as a philosophical decision.
okay, so Representative Newell, and then we are going to, because I think there was a miscount. I feel like it's really important for us to retake the vote, but Representative Newell, you have the floor.
Thank you, Madam Chair. Could I just ask Representative Libby once again, just to clarify her position for the motion to table? There was something on the end of it that I didn't hear. Thank you.
My motion was to table until my leads could be present, Representative Hagan and Senator Kine. They both had to be absent.
So the motion, the pending motion is a motion to table LD 222. Those in favor of the motion to table, please signify by raising your hands.
1, 2, 3, 4, 5, 6, 7, 8.
And those opposed?
3.
So the motion to table carries, and this matter is tabled until we can schedule it for a work session when the leads will be present. Thank you, everyone, for your heartfelt conversation about LD 222. And at this point, the work session that bill has been tabled, and we will move on to our work session on LD 192. And that is an act to define the responsibilities of residential property owners for the maintenance and repair of private roads. It is Senator Bailey's bill, and she did ask me to communicate with her. She's in an AFA meeting, so let me just quickly reach out to her and see if she is available. Okay, and we'll just give her 1 minute to respond and hopefully join us. If she is not able to join us quickly, we will move on to our third bill, which is LD 355. Check and see if she's joined our meeting. Yeah, I haven't heard back from her, so let's move on to LD 355 at this point. And And then we'll reach out to Senator Bailey shortly. So LD 355 is an act to require pest disclosure in all real estate transactions. The sponsor is Representative John Connor, and I believe he is available and is joining the panel right now. Thank you, Representative Connor, and we'll just ask you to sit and listen while we hear from our analyst. And Peggy, you may go ahead. Thank you very much.
Thank you. So this is your first work session on this bill. The bill amends the current law that applies to residential real.
I'm sorry to interrupt you. I didn't realize that Senator Bailey is actually here.
Oh.
And just because I know that she is voting on matters in AFA as well, and it's tricky for her to get away, we are going to jump backwards in time just a little bit and do our hearing on LD 192. So sorry, everybody, for the switching back and forth, and we'll be with you shortly, Representative Connor.
Okay, LD 192 was put in because people who live on private roads or have residential property on private roads have a hard time getting financing that goes through the secondary market. And because if there's no either agreement or contract for the maintenance of those private roads that the residence is on. And the purpose of the bill was to provide a default. If there wasn't a road association that had a maintenance agreement, or people on the road hadn't entered into some kind of oral agreement or written contract for maintenance of the road, this is kind of the fallback. And it establishes a new chapter in Title 23, which deals with roads. I'm sorry, it's a new subchapter. And it just applies to private roads that benefit residential properties. And it only applies when there's not already some sort of agreement or covenant or something else that directs the responsibility for the maintenance of the roads. And this fallback procedure it's an equal share in whatever the maintenance costs are of the road. There are exceptions. The exceptions are private roads that are constructed or primarily used for commercial or forest management purposes. When there's a ground lease involved, we usually think of those as camps. And I think that's the only two real exemptions. I know that there were some questions that a couple of the members had talked to Andy Cashman about, and he had provided some written answers to them. And I don't know if you want to go over those or if you want him to talk about those. But one of the concerns was what happens if there's an existing agreement and then this law passes, and this is actually because it requires, it would establish equal share. If somebody who's already in agreement thinks this is a better deal, this default, what happens? Well, there is a provision that says subsection 4 of the bill, in the event of any conflict between the provisions of this section and an agreement, restrictive covenant, declaration, road association, or other method, the terms of the agreement, restriction, covenant, declaration, road association, or method elected in section 3101 control. So this is only the default. If there's something else in existence, you can't just ditch it and expect this to apply.
Thank you. Was that all of the questions that had been asked and answered by Mr. Cashman? If you could just summarize the others as well, please.
Sure. There was a question about what happens for snow plowing and maintenance. Would seasonal residents now be made to pay for plowing and maintenance if they are not currently? Well, if they already have an agreement that doesn't deal with snow plowing, maybe they're summer residents only, so their agreement only deals with that, the road, maintaining the road, that's the totality of the agreement, then this would not change that requirement. And there was somebody else who sent in some written testimony that had a lot of questions and a lot of kind of hypothetical questions. And it really does mean residential property. It doesn't mean, vacant lots that are in an area. And it applies to properties that share a common benefit to the private road. So I don't know if you read all that testimony, but there was some concern about there were some lots that were created, like camp lots that are created that have water access instead of road access. This doesn't apply to them because they're not on a private road. So this wouldn't apply to them. So I think those were the central pieces.
Thank you. Representative Reckitt?
Yes, with great pleasure. I move on to pass.
Is there a second? Representative Poirier, were you seconding or?
I would second, yes.
Okay, terrific. Is there any discussion on the measure? I am not seeing any discussion. It looks like the committee is ready for a vote. Representative Reckitt, did you want to raise another point or you?
No, I'm sorry. I was just so excited after 5 years of this process to have it come to fruition that I was just exuberant. So I left my hand up in case there was another one to clap with. So.
I was actually going to ask you, or in part of the discussion, ask you why you were so exuberant, and if you want to give us a minute.
No, really. It's just that we've been debating essentially this issue for my 5 years now in the legislature, and I have a sort of a reputation for not having a lot of patience about private road bills, and so I asked for the honor of making the motion to pass this. So.
All right, I think on that happy note, we will move on to a roll call vote on LD 192. Okay.
Ready to go?
We are ready when you are, Soupy. Thank you.
Thank you. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Downs.
Yes.
Representative Downs votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos.
I stepped out to speak to my aide just for 10 seconds, and is this ought to pass?
Yeah.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Senator Sanborn. Senator Sanborn is absent. Senator Kime. Senator Kime is absent. Representative Hagan. Representative Hagan is absent. 11 members voting in the affirmative, 3 members absent is the vote.
Thank you very much, Soupy. And this concludes the work session on LD 192. And a special thanks to the bill sponsor, Senator Bailey, for joining us this afternoon and for bringing the bill that resolves our conversations about private roads. We'll move on now, and thank you, Representative Connor, for your patience. We will move on to LD 355. and give Peggy, I've been switching back and forth on you. Are you okay to go?
I'm good. I'm good. You don't want to look at my office, but I'm good.
Okay. Thank you for being so understanding and flexible. Would you like to give us your analysis of this legislation?
Sure. So current law requires when there's residential property being sold that the seller provide disclosure of any known defects. And there's a whole list in the statute, but including heat, the heating system, asbestos, lead paint for anything that's older than 1978. Those are some of the hazardous materials, and the statute says the presence or prior removal of hazardous materials or elements on the residential real property, including but not limited to, and then it lists those that I just mentioned. What this bill would do is amend that subsection. So in addition to disclosing any known defect, so the seller has to know about the defect in order to disclose it. This would amend the provision about hazardous materials to include pest or wildlife infiltration, and specifically describing pest or wildlife infiltration within the last 5 years and any steps taken to remedy the infiltration. So the law provides that the disclosure statement and any supplement that the seller provides are not a warranty by the seller. It's for disclosure, but it's not intended to be part of any contract between the purchaser and the seller. But it is supposed to put the buyer on notice. The buyer is expected to do an inspection, and then once there's an inspection, the buyer can follow up and they can negotiate with the seller if anything is found that is not what's expected by the buyer. Representative Connor provided you, I don't know if you saw in your email, several different disclosure forms from other states. And Maine does not specifically mention pests or wildlife. And this would require the form to be amended to include that. There was concern by realtors that the language might be kind of vague, describing pests or wildlife infiltration. And they were willing to change their educational materials to help sellers and buyers recognize that that might be a problem going forward. So just one more thing, a known defect is defined as a condition known by the seller that has a significant adverse effect on the value of property, significantly impairs the health or safety of future occupants of the property, or if not repaired, removed, or replaced, significantly shortens the expected normal life of the premises. So if you remember, this was triggered by a bat infestation in a home. And the question was, should that have been disclosed under the current law? And if not, do you want to amend the law to make sure something like that would be required to be disclosed by the seller?
Thank you very much. I see that Representative Moriarty has his hand raised. Go ahead, Representative Moriarty.
Thank you, Madam Chair. Peggy, I want to make sure I've understood your comments. We're looking at a fairly short piece of text here. It's an amendment to section 173, subparagraph 4. There is something I gather prior to this section in sequence which uses the term known or limits the applicability of the statute to known defects or conditions?
Yes.
What's the citation to that? If it's
So I thought I gave that all to you, but
Oh, maybe,
right. So so Title 33, which governs property, Section 171 has definitions. This subchapter 1A is residential property disclosures. Subsection 1 of Section 171 defines known defect. And then the required disclosures is in Section 173. And I can share my screen if you want to look at the statute, if that would be helpful.
well, I guess I'm just asking from a drafting point of view, does the presence of the term known or known defects in the same section at an earlier point carry over and apply to this subsection 4?
I'm just going to interject for just a minute because I do think screen sharing of the statute would be helpful as well, because it's a question that I see lots of nodding heads. I was doing looking at that as well, Representative Moriarty.
Sure.
Let's start with the screen sharing
That'd
and
be
then
helpful.
you can re-ask your question about the use of the word known.
Okay. So this is my document that's called current law. And is posted on our materials page. But so the first part is a definition. Here's known defect. That is a good definition for the whole chapter. There's seller property disclosure statement, which we'll get to in Section 173. It applies to residential real property. And then you get down to, I'm gonna make you dizzy, Section 173. These are the required disclosures. So unless the transaction is exempt, the seller has to provide the purchaser a property disclosure statement containing the following information. So water supply system. 2 is gone, we repealed that, but 2A is the heating system or heating source. A lot of details about that. Waste disposal system. And then here's the section that's being amended, hazardous materials. So this lead-in would be amended to include pest and wildlife infiltrations. And the bill would add a new paragraph F. But here's where the known defects come in. This is a required piece of the disclosure, any known defects. And then one of the things that Representative Reckitt will remember is disclosing what the access is to the property, whether it's on a private road, which the other bill would deal with, or if it's on how you can access the property. So that has to be disclosed if the seller knows. So known defects is kind of a standalone item that has to be disclosed. It's not anything, nothing is listed there specifically. It's whatever falls under that definition of known defect. So is it going to be a health and safety risk? Is it going to diminish the value of the property? Or if it's not repaired, will it reduce the longevity of the property?
Can you scroll back?
Yeah.
Can you scroll back to 171, subparagraph 1?
Yep.
And known defect. Well, the issue, I guess, is whether pest or wildlife infiltration falls within the existing scope of the term known defect, or whether it merits separate treatment.
I think you just explained the bill.
The point is, we've had comment to the effect that this is already covered. And I think you've shown us probably the basis for that viewpoint, which makes some sense, but it's not quite as specific as the proposed modifications to subsection 4.
Okay to stop sharing?
No, no. May I see the introductory paragraph to 173?
Representative Babbage, let me
Oh,
just
thank you.
ask you, because Representative Libby had her hand raised.
Okay.
Representative Libby, does your question relate to something that we need the screen sharing for, or is it something else?
Don't know that we need screen sharing. It's simply this. So in the section, now I can't remember which section it was, but it was residential real property. So is that defined above? And it residential. So that just includes the residential dwelling unit. Is that correct? I'm sorry, I can't see part of it because of the.
Right. So residential property means real estate consisting of one or not more than 4 residential dwelling units. So you could have up to 4 residential dwelling units on the real property. So it would also include like a multi-unit building.
So, but
I'm sorry, go ahead.
Sorry, but it would not include, as was brought up during, there was a question about it during the hearing about if that would include outbuildings and that sort of accessory building. So it would include accessory dwellings, but not a shed or chicken coop or something like that. Is that?
I don't know that. People who work in this probably are more attuned to what that means in the trade. I don't know that there is a definition in this chapter about disclosures. I'm sorry if I'm making you dizzy as I'm scrolling through.
And so the question is whether residential real property encompasses everything that one would purchase, for example, versus does it just refer to the structure that people reside in?
Correct.
Right.
Okay.
And I know that Representative Connor, his interpretation of that is it just is the dwelling. It's the actual residence.
Well, and that seems like that's the context for the other things listed in number 4, the hazardous materials that are already there with asbestos and lead-based paint and methamphetamine. Or are those all for the entire property?
I mean, again, you might want to talk to people who actually practice real estate, because I could see like if you have an unguarded well on the property, that would be a known defect, and that wouldn't necessarily be part of the residence itself, or some kind of I mean, there is a waste disposal system, but what if there, well, I guess that would be hazardous materials.
At this point,
sorry.
No, this is all really helpful. I'm trying to think of the best way to move forward to get a little input. And so, Peggy, are there other aspects of the bill analysis that you would like? I'm not sure how far you got in your bill.
No, I think that's fine. I tried to explain kind of the context of how these disclosures work. And I think you figured out what the bill is about and what it would do. So I'm done.
Okay, I think at this point, we're going to ask you more questions. I'm 100% sure of that. However, I think at this point, it would be important to hear from both the bill sponsor, Representative Connor, and also I'm going to, let's hear from Representative Connor, and then we will ask Mr. Cashman to join us and weigh in on this issue as well. But as the bill sponsor, Mr. Connor, we'd be really interested in hearing from you first.
Thank you, Madam Chair and members of the committee. I'd like to go back to Representative Moriarty's point when he asked the question of, does this fall under the known defects clause? And I would point the committee to last session. you could ask that same question about methamphetamines. Would methamphetamines being on the property consist as a known defect? And this committee warranted that it rose to its own line item on the disclosure document. It could also be a known defect, but it had that much significance that it warranted its own line item. The same could be said about the chimney inspections. That could be a known defect, but it rose to the level of needing its own line. And so when we talk about pests being so wide and broad, I would go even further to say that known defects can be even wider. So this bill aims to narrow down at least one aspect of the known defects, which is the pests. And as I stated in my additional documentation to you guys, what I found is that this not only, I originally wanted this to protect the buyer, but what we found is that it really protects both, because if a known defect as bats, if it didn't come up at the sale, then a seller could be held liable for it, as Mr. Cashman said, that this should have been disclosed. So this is aimed at protecting both the seller and the buyer in the transaction. So we feel that the pest disclosure rises to a level outside of the known defects, and it should have its own line item, just as some of those other items have their own line item.
Thank you very much, Mr. Connor. I have neglected to recognize two of my colleagues who raised their hands when our analyst was providing information. And so let me just check in with them, and then we'll return and see if committee members have specific questions for you, Mr. Connor. Representative Harnett?
Thank you, Madam Chair. Actually, my question will be for Mr. Cashman.
Okay.
Thank you.
Thank you. And Representative Rackett?
I'm troubled by the not only the broad range of things that might be considered pests and the ease with which theoretically you could get rid of them. Whereas if you have methamphetamine, it's like a huge big deal to have that cleaned. It's expensive. It's blah, blah, blah. It's not like calling an exterminator. And so it worries me that we would get ourselves into a place where we start metaphorically talking about dripping faucets, which, and we're not talking about, but I mean, it's around that level to me. Now, I say that in part because I caught a mouse last week in my house, and I caught one, I think 6 years ago, but I don't remember when I did that or where it was, so it just seems to me pests is too amorphous a word to warrant a real estate disclosure. I mean, if you had an infestation is one thing, but if you knew that you had ants in the spring, I'm not sure that's an odd enough thing in Maine to have in a real estate disclosure. And you can't always know that some years I don't have ants in the spring and I haven't done anything about it. So it's a transitory thing in some ways. So I'm uncomfortable with this bill just because of I can't grasp it in my head.
Representative Connor, did you have a response to that?
Yes, Madam Chair. Representative Rickett, I would agree with you. The level of methamphetamines can definitely be much larger, but I believe the statute says if there's any methamphetamines in the property at all, it wouldn't necessarily need to be a massive cleanup job. But that rises to the level of disclosure. And to your point of the mouse or the ants, we agree that there definitely needs to be some level of discretion on the part of the seller. We're not asking, this bill is not aimed at stating if you catch a mouse once this year and once 6 years ago that you should have to disclose that. We've all left our door open every now and then and a critter got in and we got rid of it and that was that. Completely open to the word infestation being added to this. We really think that this can cause, pests can cause structural damage. I believe in the public testimony, if a bunch of squirrels or chipmunks got into your walls and started chewing your insulation and wires, that could lead to structural, integrity issues. So we know that there needs to be some level of discretion amongst the sellers. Again, this is a memory jogger to put it on to the disclosure document to protect themselves as well as protect the buyer.
Thank you.
Representative Evangelist, did you have a question for the bill sponsor? Or a
No.
general comment?
Just an idea that I want to clarify. I need a clarification.
Does it involve, I just want to wrap up our questions with the bill sponsor before we bring Mr. Cashman in. Do you want to make your statement in this context?
Not necessarily.
Okay. And Representative Poirier, did you have a question related to Mr. Connor? Okay, go ahead.
Yes, thank you, Madam Chair. Just looking at the broadness of the language on the bill, I'm wondering if that language is indeed needed, where we have wording on purchase agreements that do actually reflect the buyer's ability to set a time frame where they actually have the ability to set that time frame where they can utilize an inspector to look things over like that. And pest is actually one of the items on that agreement. So it looks like that information is part of the buyer's responsibility to look into with an inspection. So I'm wondering if this is really necessary to have in the statute when it's something that even after the purchase agreement is filled out, when you're looking at that agreement, they can set a time frame after the sale to be able to go back to the seller and let them know, hey, we found something, we need to fix this.
Thank you, Representative. In answer to your question, I'm glad you brought that up. So the way that we look at this is the disclosure document is what sets everything in motion. So when the buyer is coming to the property and they're in their negotiations, they are going to base their inspections 9 times out of 10 off of the disclosure. If you look at all 25, I believe there's 25 different inspection items on the purchase and sale agreement. If every buyer were to find a specialized inspector for all of those items, some of those are specialized. A normal inspector might not check all of those items. So a buyer is not necessarily going to go out and hire a specialized inspector for all of these items. What they're going to do is they're going to rely on the disclosure document. And if something jumps out at them on the disclosure document, then they can go ahead and pay that extra money for the specialized inspector. So in the instance of this particular bill with the bats, if the sellers would have said, yes, we had bats in the past and we had some infestations, that would have triggered the buyers to then hire a specialized inspector, a pest inspector, if you will, to come out and check and do that type of inspection. So we're looking at it from the standpoint of the disclosure document triggers the other inspections that come down the line. Some of these might not be picked up by just an ordinary inspection, a building inspector, or I'm sorry, a home inspector. So that is our take on it, is that it's triggered by the disclosure document. And if the disclosure states that there's a pest or any other item on there, then that'll hone in the buyer's inspections.
I see a number of hands up. Representative Moriarty, is your question for the bill sponsor, or does it relate to something else?
It is, actually.
Okay, go ahead, and then we'll pull Mr. Cashman in.
Mr. Connor, I just want to ask about your thoughts about a possible modification to the very first portion of subsection 4 before you get to the list of lettered subparagraphs. If we substituted the word residence for residential real property, would you be supportive of that change?
Yes, sir. I would not be opposed to that. I think the real estate board may have other answers, but I'd be fine with that.
Thank you.
It's a very quick question. Thanks, Representative Moriarty. Other questions for Mr. Connor, or would we like to run some of these ideas by Mr. Cashman as well? Representative Evangelos, why don't you go ahead and ask your question at this point?
Well, my wife would argue that she'd have to disclose I live there, but I do have a thought. So, you know, when sometimes we move and the house stays empty for several months, and everyone knows these main farmhouses. A lot of times, maybe you had a cat like we do, but sometimes mice and other things move into an empty home, and the seller wouldn't have known it. You know, they've moved to Montana, and the house is in Maine. Real estate agent is handling the sale for you and calls you up and the house is sold. So I'm a little worried about, you know, that scenario where the pests are likely to move in when people aren't living there. That's very common with bats, by the way. So I'm just throwing that out there. I'm not sure. I don't want the seller to get in trouble for something they truly didn't know about when the pests arrive after they put the house up for sale and left.
Thank you, Representative Evangelos. Welcome, Mr. Cashman. As you've been listening, you've probably realized that we have a number of questions for you. The first one will be by Representative Harnett.
Thank you very much, Madam Chair. I disappeared there into the ether for about 5 minutes, but I made it back. Mr. Cashman, my question has to do with the term that we are discussing, known defects. And I am looking at the disclosure notice that you or somebody put into testimony, and I am not seeing that mentioned anywhere. Can you point to me what I'm missing?
So I thank you, Representative, and members of the committee. It's nice to see all of you. I think that the issue may be looking at 173 in terms of the required disclosure.
Correct.
In 173.4 is the hazardous materials language,
Yep.
and then sub 5 is known defect.
Right.
And then I'm sorry.
I'm looking at the property disclosure form, the 7-page form that somebody put into testimony, and I'm not finding where that question is asked, and I assume I'm just missing it.
Okay, if you are looking at our form, that would be on page 6. And it's the last part of section 5, where it says known material defects about physical condition and or value of property, including those that may have an adverse impact on health and safety.
Okay, I see. I guess I was thrown off by the word material, because the material, it's simply known defects in the statute.
Yes, yep.
So you guys dressed it up a little more.
Yeah, we try to be clear in what's required. And that's, known defect, again, that's referencing back to that language that's in the statute impacting health, safety, and wellness and value of the property.
It doesn't mirror it exactly, but it summarizes it.
That's right, Representative.
Thank you.
Thank you.
Yeah, and I would just like to make an observation, because I too I'm concerned about that same issue when you precede it with all caps known material defects. It seems to exclude something like bats that are living in the house. It just doesn't seem to jog the memory of somebody who's dealing with a very potentially very harmful infestation. I'm not sure how to resolve it. It just is a concern to me as well.
Well, yeah, thank you. Sorry.
Did you want to respond?
Well, I was just going to say that I think that we're trying to harken back to that definition section of a known defect. And so it is the concern that you have the insertion of the word material there, is that?
Yeah, I think when you preface the disclosure form with material defect, it seems like it issue has to do with, for example, termites eating structural wood and not with potentially, animals that carry potentially fatal diseases
Yeah.
coming to live in the house with the people.
So I appreciate that, Senator. If I may, I think that the reason that material is included is that it's trying to indicate that it's something substantial, and then we try to, so I mean, you could be aware of a defect could be as small as a scratch on the floor or something like that, and somebody could argue, well, that's, then you get into whether it's a material defect, and I think that we're trying to qualify that in the definition by saying that it's about the physical condition or the value, and saying again that it has an adverse impact on health and safety. So I think that's why that language is there. I appreciate what you're saying, and yeah.
Thank you for addressing that. Representative Libby?
Thank you, Madam Chair. I guess that was my question. Before seeing this form, I hadn't known that the word material had been added in. And to me, that speaks to the materials. This is my non-lawyer thought here. That speaks to me of the materials, literally the materials that make up a home. And so I think that's where my confusion lies, is that I don't think your average home seller is going to understand that difference, that differentiation, without extensive education from their realtor, which may or may not happen.
I appreciate that, Representative. And I mean, if that's a common concern, we'd certainly offer to remove the word material there. I think I was just trying to explain why that was there, but I can appreciate that, and we could remove that if that would be helpful for the committee.
Thank you.
Thank you, Representative Libby. Representative Harnett, and then Representative Babbage.
Thank you, Madam Chair. And not to continue to quibble, but the use of the word material and then the example that you gave, a scratch on the floor.
Mm-hmm.
Looking at section 171, a definition of known defect, I can't imagine anyone making a serious argument with that definition that a scratch on the floor would meet that definition.
Yeah, sir.
Material it adds a flavor that's not in the statutory definition.
Mm-hmm. Thank you, Representative. And I appreciate the feedback on that. I understand. I think, this form is trying to live in two worlds, between the statutory requirement and also making sure that it's properly exercised, out in the real world. And so I think material was there to try to indicate, it's not any single scratch on the floor defect, it's something substantial that impacts health, safety, and wellness. But again, we appreciate that, and it's good feedback that we could remove.
Representative Babbage?
Thank you, Madam Chair. I just wanted to, with Representative Connor here and Mr. Cashman, I just wanted to say that I appreciate the intent of the proposed legislation, but I'm very wary. I think I'm along with Representative Rackett on trying to address behavioral problems. Is what I consider them. So the material defect part means something to me. If somebody knows something that has caused structural damage, then I think that's different than, oh yeah, I put out a mousetrap 3 years ago. Or, when you start talking about the potential bother, what's the word? The malady or the quality of life issue of a pest or a crow in the backyard that makes too much noise at 4 in the morning, or for that matter, a neighbor's barking dog. That that's not something that I think needs to be necessarily disclosed. I do think the onus here is on the buyer to direct his home inspector to be sure to look at certain things if that's important to them. I am sympathetic to the bat situation that the sponsor brings up, because that seemed like it was an ongoing occurrence that was unremedied. But if it's not structural to the basic part of the home, then I think that disclosure would be nice, but I don't want it to be a basis of litigation against the seller. I think that's slippery slope.
If I may, Madam Chair.
Yeah, just a brief response because we've got many
Sure.
work ahead of us.
No, and I just wanted to comment on, so Representative, I appreciate that. And that really goes down to our fundamental concern with the bill is that the vagueness of the language, how you define pest or wildlife, and infiltration or infestation even, but those are all terms that have some level of subjectivity to them depending on who is hearing them, right? And that's a concern that if you put something, the other topics that are under there that are in the law that are specifically laid out, like methamphetamine, those are clear things. They're pretty binary. The idea of pests is more subjective. So the vagueness of it is a concern for us from a litigation standpoint and from a reputation standpoint for our members, because at the end of the day, we're being held to a certain standard. And if it's vague, it's not clear how we abide by that. So that's why taking a step back and saying a known defect is important, because it captures the essence of the problem around a pest or wildlife or anything else. It's something that's bad about the property that is going to impact health or safety of the people or the value of the property itself. So I appreciate it. Thank you for that.
Thank you, Mr. Cashman. Representative Poirier.
Thank you, Madam Chair, and welcome, Mr. Cashman.
Thank you.
My question is on the property disclosure form. I just want clarification as far as the filling out of that form. Is it the realtor's responsibility to make sure that the seller knows what they're supposed to be filling out on that form? Do you have to clarify with them that, hey, under this known material defects, that's where you would put in things such as issues
Absolutely.
such as
Yes, absolutely. That's part of the discussion with the client, is walking through that form and explaining this. Absolutely. Thank you.
Representative Libby.
Thank you. I understand that there's some vagueness and it's left to discretion with this bill. I just wonder if there is a way to define it more clearly. And we heard Representative Reckitt talking about her very, very occasional mouse. And now when my family moved into our farmhouse recently, we have not caught the occasional mouse. I could tell you that we have now caught 22 mice and 2 squirrels. So if we ever sell our home, I'm on record. Those are two obviously extremely different scenarios. And I wonder if you could speak to, our house did sit empty and I think critters moved in, but if that had not been the case and there had been sellers in our home right until when we moved in, was that a scenario you would have expected this to be included in the disclosure? By the way, we do have a mouse infestation and you'll get the occasional squirrel. Or is that something that the current statute says, well, maybe you should, maybe you shouldn't?
Yeah, no, I think that it would be, because if you stepping back from it again and you say, okay, so is the presence of multiple mice in the house that you know about, is that something that could affect the health, safety, or wellness and the value of the property? And yes to all of the above, with mice and with bats too, for that matter. I mean, there are known germs that are contained in the feces of mice. Mice tend to gnaw into electrical wiring and so on and so forth. So yes, that would absolutely need to be something that would have been disclosed. And it says known because it's something that it wouldn't be fair if you weren't aware of that. You don't open up all the walls every day and look at every aspect and nook and cranny. So that's a reasonable expectation to say, if you knew about that, if you knew that there were mice, then you ought to disclose that.
So just a quick follow-up, if that's okay, Madam Chair.
Go ahead.
So what, in your opinion then, is if this language is too broad, what is the, in your thought on what is the best solution to, in the BAT scenario that was not disclosed and should have been? So how do we, without, if this bill is not the answer, then how do we get to a place where folks are not walking in that gray space and getting away with not disclosing things that should be disclosed? I guess that's, that's what this bill is trying to address. So how can we ensure that folks are indeed disclosing things that are not gray but are black and white and should be disclosed?
Yeah, I mean, I think in this case, it was unfortunate that they didn't disclose it when they should have. And unfortunately, with disclosure issues, that those come up, it's not uncommon to have disagreements over, whether something was in there or not. There's mediation in place for that. And I think in this case, the resolution to that was a good one. It was a bad situation for the buyers. I can certainly empathize with that. But at the end of the day, the realtors did come together and help split, the costs, and they were able to address it and work through it. There was no litigation or anything like that. So I think part of it is the reality of the situation, which is why our members are always telling people that you want to just err on the side of more disclosure rather than less. If there's anything that that would qualify under that needs to be there.
Thank you, Mr. Cashman. And thank you, Representative Libby. Representative Moriarty?
Thank you, Madam Chair. At the appropriate time, I'm prepared to offer an amendment and an accompanying motion.
You may proceed with your motion.
Okay, I move ought to pass as amended, and let me explain the amendment. It's fairly brief and clear. Looking at the paragraph labeled number 4 in boldface, we see the existing language, hazardous materials, semicolon, pest or wildlife infiltration, period. No change there. However, in the next sentence, I suggest that it read the known presence or prior removal of hazardous materials or elements, comma, and then the same underscored language as appears currently. And then at the comma after the capital letter F, I propose deleting the words on the residential real property and replacing them with the words within the residence. And then followed by a comma, including but not limited to, colon, and the rest of it as printed.
Is there a second? Representative Newell?
Yes, thank you, Madam Chair. Did you call for a second?
Yes, thank you. So
Second. Thank you.
motion to amend by Representative Moriarty and a second by Representative Newell. Is there any discussion of the motion?
Could I speak to it very briefly?
Yes, please
Okay.
speak to the motion first, Representative Moriarty.
First of all, although I understand now from Peggy's presentation that the word known appears at a prior portion of the statute, I think using it again in this location or in this subsection is useful, as it's dealing directly with pest or wildlife infiltration, whereas the prior paragraph is more generic in nature. As to the reference to the residence, that addresses the commentary to the effect that a buyer should not be required to disclose what lives in the backyard or lives in the woodlot adjacent to the dwelling, and what walks through the yard from time to time. And it focuses strictly on the residents. And as you heard earlier, I asked Representative Connor if he was on board with that change, and he indicated that he was. That's all I have to offer.
Thank you very much. Representative Libby?
Thank you. I understand that would suit Representative Connor's purposes, but that would take out the context for other issues mentioned under number 4, such as underground oil storage tanks, as well as methamphetamines, which could be in the residence itself, but could also be in any outbuildings, sheds, etc. And it also would be problematic for the lead-based paint and asbestos. Asbestos siding is commonly used, and that could be on outbuildings, garages, other buildings that aren't the residence itself. So while I appreciate the intention and idea, I think it's the pest issue in the residence is a separate issue from the residential real property.
I'd also like to comment. I appreciate your efforts, Representative Moriarty, to address this issue because I think it is a real and very serious issue. I am concerned that we haven't quite hit the right mark on how to address it because we have this distinction between the real estate versus the building, and then the criteria, as Representative Libby mentioned, the criteria in paragraph 4 seem to cross both of those boundaries. And I'm just not sure. I've been in my own mind trying to figure out how to come up with an amendment that will address the problems that have been described without creating inconsistencies in other aspects of the law. And I'm not sure we're there yet, but I do really appreciate all of the thought you've put into the amendment. Are other committee members, do they have comments that they would like to share on the motion to amend? Representative Babbage, go ahead.
I think Representative Moriarty's amendment improves it a great deal for me. But in order for me to vote for it, the fact that it's a known presence is important. He's reduced it to residents, which is great. But for me, it would still need to be structural damage. It would still need to be wires having been, something that would be passed along to a buyer that amounts to the condition of the home beyond the presence of the animal, but that there's been harm caused by the animal that exists. So I'm not on board yet.
Other committee members, feedback and comments on the pending motion? Representative Rackett?
I'm in a place where I can't grasp why what we currently have properly disclosed by the realtors and enforced by whatever enforces that wouldn't work just as well. So I'm not really there yet either. And I'm not certain I need to be. And that's my problem.
Representative Harnett and then Representative Sheehan.
Thank you, Madam Chair. I just want to agree with both you, Madam Chair, that we're moving in perhaps in a good direction, but we're just not striking the balance. And I think the observation about taking out the word residential property as it applies to all those other subparts of that section is problematic. And I don't know the way to resolve that. Because I would be concerned about methamphetamines and asbestos anywhere on the property. And I'm sure that was not the intent to limit those other types of defects, but I think it has that effect.
Thank you, Representative Sheehan.
Yeah, I just wanted to say that after hearing all of this discussion, I'm inclined to think that what we currently have is probably the best. If professionalized real estate agents are doing their work and guiding buyers and sellers on the basis of existing statute, the disclosure form, which I agree could be improved, removing the word material, and the purchase and sale agreement, it just seems it seems like so far the best solution to these problems.
Do other committee members have comments that they would like to share? Representative Libby?
I apologize. My comment is not to this motion, so perhaps I should wait until after we're done with this motion.
Okay, thank you. Other comments pertaining to this motion? I'm not seeing any raised hands. So at this point, Supi, I believe that we are ready for a vote on the motion by Representative Moriarty, seconded by Representative Newell, to would be an ought to pass as amended on LD one. Oops, hold on, let me figure out where we are here. Thank you, LD 355. The amendment articulated by Representative Moriarty, inserting the word known. And Representative Moriarty, could you please refresh us as to the contours of the amendment one more time? We're not able to hear you.
I can read the initial introductory sentence for hazardous materials, pest or wildlife infiltration. The known presence or prior removal of hazardous materials or elements or pests or wildlife as described in paragraph F within the residence, including but not limited to, colon, and then the rest of it is unchanged.
Thank you very much. Is the committee ready for the vote? Representative Libby, did you wish to be recognized?
Yes, I'm sorry, Madam Chair. Can I please request a corner caucus?
Yes, you may. Do you?
Thank you. 5 minutes should suffice.
May I ask a procedural question?
Yes.
Is the motion before us merely the amendment and then we will have a vote on the bill, or are we replacing the bill with the amendment?
It's not, I think it's an ought to pass as amended.
Okay, thank you.
Yep.
Thank you.
So we'll return at let's return at 3:05. That will give us 10 minutes. And for those who need any additional little break, do that as well. So please turn off your video and your audio, and we'll be back at 5 after 3. Thank you.
Madam Chair, may I ask you a quick procedural question?
Yes, go ahead.
So this next vote, just to clarify, this is not a final vote on the bill. This is the vote on the amendment, correct?
I believe it is a vote on motion to pass as amended.
I have a motion to table to entertain, but I realize that would have to happen before a final vote. To table for the sponsor to work on language.
Let's wait till the entire committee
Okay.
returns.
However that works. Thank you.
Thank you.
Representative Libby? Hi.
Hello, Representative Babbage.
Hello. Well, I don't know if we can talk about, well, we are on.
We are live. We are.
I guess I'm not violating anything by talking substance then, am I?
Well, I think everybody on the committee should return. Representative Moriarty, who's made the motion, is not quite back with us yet. And so let's, since it's his motion, let's wait, give him another moment to return.
I don't think.
Representative Moriarty, are you, there you are. Before you rejoined us, Representative Libby indicated that she wanted to be recognized for the purpose of making a motion to table. And at this point, we are obligated to take up that motion.
I think it takes priority.
Yeah. And so is that your motion, Representative Libby?
Yes,
hold on a second. Is there
Yes.
is there a second? And Representative Hagan has seconded that. And motions to table are non-debatable, I believe. And so we will move on to a vote on the motion to table. And we will do this. We've been encouraged to do everything by roll call vote, given our electronic format. And so Supi, if we can prevail upon you to call the roll. And Representative Harnett, did you have a point of order that you wanted to raise?
I think it's a point of order. I'm not sure. I realize motions to table are not debatable, but do we have a reason for the motion? Do you need to provide a reason?
I do have a reason if I am allowed to speak to it.
Yes.
Thank you.
You had mentioned it earlier.
Yes. Sorry, not everyone was on, so I will restate. I would like to move to table it so that the sponsor can take more time to work on the language. I feel like buying a home is one of the very most substantial investments that many folks will make in their lifetime. And so to give this this issue, which I realize is a very small bill, but to give it the consideration that such a large investment is due, I feel it would behoove us to allow the sponsor to work on the language a bit and bring it back to us. So that's why I moved to table for now.
Thank you. And thank you for requesting the restatement of the explanation, Representative Arnett. And with that, Supi, I think we're ready for the vote.
Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty. Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Downs.
Yes.
Representative Downs votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos. Representative Newell.
Yes.
Representative Newell votes yes. Senator Sanborn. Senator Sanborn is absent. Senator Keim. Senator Keim is absent. Representative Evangelos. Representative Evangelos is absent. 11 members voting yes, 3 members absent. That is the vote.
Thank you very much, Ms. Panett. And Representative Connor, I just wanted to encourage you also to reach out to Mr. Cashman. I think that having a conversation between the two of you maybe would help get to where you want to be on the bill. And we appreciate your being here both to present the bill and for the work session.
Thank you, Madam Chair. I will do that.
Mr. Cashman, same to you as well. Thank you. Okay, that brings the work session on LD 355 is now closed. We are moving on to LD 237, which is an act to allow veterans to opt out of jury duty, sponsored by Representative Grochowski of Ellsworth. And I'm just going to check to see if Representative Grochowski is in the attendee space. I will invite her to join us if, Peggy, if you would like to begin the bill analysis, please.
Sure. So this is LD 237. It amends the statute that provides for excuses from jury service. So there are 2 statutes that address who can serve on a jury. There are some disqualifications, and then there are also exemptions. that is Title 14, Section 1211. This bill amends Section 1213, which is excuses from jury duty. And those are, instead of saying you're totally exempt, but it actually says you can ask to be excused from jury duty. And this gives you authority to ask to be excused. This would apply to a person who served in the United States Armed Forces and received an honorable discharge or general discharge under honorable conditions, who does not wish to serve on a jury. It would allow them to be excused from jury duty. And actually, Representative Libby had asked for the history of all the changes to this statute, and it's been interesting. That's in your bill analysis, but the biggest change was really in 2017, when the exemptions used to include the governor, judges, physicians and dentists providing active patient care, veterinarians with or in an active veterinary medicine practice, sheriffs, attorneys at law, and all persons exempt under 37B 185, which is National Guard, I believe, on duty. that was amended in 2017 to leave the exemptions as the governor, active duty military, and those that are exempt under 37B.
Thank you. Do any members of the committee have any questions for our analyst? I'm not seeing any questions. Representative Grahowski, it's so nice to see you this afternoon. Welcome back to the Judiciary Committee. Did you have any additional information you'd like to provide to the committee?
Thank you, Senator Carney. Good to see you all again, even at an earlier hour than the last time I visited. I just want to thank the committee for the great questions that you asked during the public hearing. And I also want to thank Julie Finn for a really helpful conversation that I've had with her in the interim. And I think I personally have learned a lot about the juror selection process. I will comment that it was disappointing to me to hear that as wide as we have made the pool, there are still challenges, it sounds like, to getting people to serve on a jury. I'm definitely interested to hear what thoughts this committee has, but I recognize that we are in a challenging situation, especially due to COVID. And I understand that everyone's views on where this bill should go, I think are probably valid, are of course valid, and that I don't have a strong feeling about the need for it compared to the need for having people to serve in juries. And I do want to add that I learned, I don't know if anyone else was interested in this part of my testimony, but the concern about people serving on juries in really traumatic cases, that we don't really have a way to help them after the fact. So I'm hoping to follow up with the judicial branch about creating some sort of system of outreach or information that can be shared with jurors in these traumatic, really challenging cases to make sure that people don't go home and feel alone dealing with the problems that they've encountered in their service. So that actually has come to the top for me as a concern. And I want to let you know that I'm going to try to work on that outside of the legislative process. And if that doesn't work, then I might be back at some point in some future session with some more ideas on that, because I really, really want to make sure that people who do step up to serve are supported throughout their period of dealing with whatever might come up for them. So thank you for just letting me speak in an ad hoc fashion at this point. And I really appreciate everyone's interest in the topic.
Yeah, we appreciate your dedication and focus to this issue. And I'm personally am really grateful that you're going to continue to look into the issue of how to help jurors after the fact, after they've served on a really difficult jury process. Thanks for that work. Are there any questions for the bill sponsor on part of committee members? Is Representative Harnett? Is there a motion? I see two hands now. Representative Harnett, I think you maybe were first. And we're not able to hear you.
Thank you, Madam Chair. I'd like to make a motion and speak to my motion.
You may.
Thank you. Thank you, Representative Grahowski, for being here and for introducing the bill. And it feels a little odd being a co-sponsor to make this motion, but I'm going to make a motion ought not to pass. And I just want to explain why. I think your intent was well-grounded, and the issue that persuaded me was the loss of 12%, the possible loss, because I don't think 100% of people, the veterans, would take advantage of this. But the potential loss of 12% of a juror pool when we have a difficult time filling juries, and also maybe losing a balance of veterans in the juror pool that can provide different insights into matters being considered by the courts. And I appreciate your focus not just on veterans, but on other people who might have adverse experiences from serving on jurors dealing with serious and traumatic issues. But given the possible ramifications, that's where I'm moving ought not to pass. Thank you.
Is there a second? Representative Poirier, thank you for your second. So motion of ought not to pass by Representative Harnett, seconded by Representative Poirier. Is there any discussion on the motion? We have Representative Libby, go ahead.
Thank you, Madam Chair, and thank you for being here today, Representative Grochowski. I just wanted to thank Representative Grochowski for bringing this up. Researching this issue actually also helped me understand the system a little better, being new to the Judiciary Committee. And actually research on this bill helped me with another bill. So I'm really thankful that Representative Grochowski brought it up because it's helped me in a number of areas. So thank you very much.
Representative Babbage?
Yes, I'm on. Yes, I just wanted to welcome Representative Grochowski to Judiciary once again. And I wanted to also explain that I think Representative Harnett hit the major points, but I also feel that in our obligation to veterans, I really want to provide them with every chance to reintegrate into civilian life and citizenship and rewards, as well as obligations, you might say. But being on a jury is not welcome by many, but it's a rewarding experience with your peers in many cases, and so we need what veterans can offer to this experience, and I think it's a mutually beneficial experience as well. So, for those reasons, I'll be supporting the motion. Thank you.
Thank you, Representative Babbage. Is the committee ready for the vote? Ms. Panett, are you ready for us?
I am absolutely ready.
We are ready for you. Okay, this is a motion ought not to pass on LD 237.
Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Downs.
Yes.
Representative Downs votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos. Representative Newell.
Yes.
Representative Newell votes yes. Senator Sanborn. Senator Sanborn is absent. Senator Keim. Senator Keim is absent. Representative Evangelos. Representative Evangelos is absent. The vote is 11 in favor, 3 are absent.
Thank you very much, Ms. Panett. And again, Representative Grochowski, thanks for bringing this thought-provoking bill to us and for all your hard work on it. The work session on LD 237 has now concluded. We'll move on to our next work session, which is LD 272, an act to establish separate prosecutorial districts in Down East Maine. The sponsor is Representative Toole, and I will bring him over from the attendee space and have him join us if he's available. and I am not seeing him available. I do see Senator Moore, and I believe she is here in his stead, so I'm going to bring her over to the panel. Representative Reckitt, did you wish to be recognized?
I'd be happy to wait for a motion to be made, and then I would like to discuss.
Would you like to make a motion?
I would, actually. As long as that wouldn't prevent me from ever discussing. I'd like to move on to pass.
And seconded by Representative Newell. Okay. Would committee members like to hear from our analysts before we move into discussion? I'm not seeing a lot of enthusiasm, but can you give us a quick synopsis, Penny, and then we'll move on to Representative Reckitt speaking to her motion.
Great. Thank you. Let me just say, this bill amends a statute that the prosecutorial districts were established in statute in 1973 when the state moved away from the county attorney process and actually brought those county attorneys sort of into the state system, so they are compensated by the state rather than the counties, and developed the 8 prosecutorial districts. They have not really been touched since then. And so this would divide prosecutorial district number 7, which consists of Hancock and Washington counties. 7 would remain just Hancock County, and new prosecutorial district 9 would be Washington County. We do not have a fiscal note for this yet. That's all I wanted to say.
Great, that's wonderful. Representative Reckitt, would you like to speak to your motion?
If I could. It's been my pleasure in the last 4 or 5 years to spend probably more time in Washington County than other counties that are outside my home. And I'm a long way from home when I'm there, except I've always felt at home. And I've done a lot of work in that area as both a consultant and as a legislator. And as some of you who were here before will remember, I was a major advocate for the Down East Correctional Center at the time that it was being dismembered. And I've worked with both people in Hancock County and in Washington County. And they're all good people, but I think the distinctions are great. And the space is great. And the distances that people have to travel in order to get things done in a prosecutorial sense doesn't make sense to me. And I think the cost of this is going to be minimal because of the shifting of prosecutors into different jurisdictions across those two. And I think that it's really important that we try to help this county that has had such a huge and horrendous drug problem, and that has had a variety of other difficulties, including widespread unemployment, difficulties in the fisheries, a million different reasons why Washington County could use a leg up. And they believe, it appears, from all the voices we heard, that this bill will help Washington County. And so that's why I'm happy to make the motion to support this bill. Thank you.
Thank you very much, Representative Reckitt. Do any other committee members wish to speak to the motion? Not seeing anyone. I believe that we are ready to move on to a vote on the motion, which is ought to pass by Representative Reckitt and seconded by Representative Newell.
Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Downs.
Sorry about that. Yes.
Representative Downs votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos. Representative Newell.
Yes.
Representative Newell votes yes. Senator Sanborn. Senator Sanborn is absent. Senator Keim. Senator Keim is absent. Representative Evangelos. Representative Evangelos is absent. 11 members voted yes. 3 members were absent. That was the vote of the committee.
Thank you very much, Ms. Panett. That we've passed LD, and I've lost where we are on the
272.
272.
Thank you, LD 272. And I see that the bill sponsor has joined us in addition to Senator Moore, and he has his hand raised, and I would like to recognize the bill sponsor first, and then we'll turn to you, Representative Hagan. Welcome.
Thank you, Madam Chair. This is Representative Will Toole. I apologize. I was in transit and lost my connection, so I'm overjoyed and thankful for the committee's decision to pass this legislation, and I want to thank you all. I think it will make a big difference for Washington County, and thank you all, and especially Representative Reckett. We have a long history and working together on issues down east, and I look forward to seeing you next week, and I treasure our friendship very much. Thank you, and thank everybody else.
Thank you very much, Representative Toole.
Good guy.
Representative Hagan?
Thank you, Madam Chair. I thought we had one member who was going to vote no, and did all of the members vote? They did? Okay. Thank you very much.
All right. I think we've completed our work on that legislation. Representative Babbage, did you have a question?
I just wanted to thank you very much, Madam Chair. I just wanted to welcome Representative Toole and thought he was quite courageous to speak after he already got his bill passed, but I will not make a motion to reconsider. So thank you.
Representative Newell?
Thank you, Madam Chair. And I just want to give thanks to the committee voting in favor of this. But I would also ask, Madam Chair, if you might consider Senator Moore is in the audience, if she's got any words to share.
That's kind of you to suggest that. And Senator Moore, please.
Thank you. Thanks for the opportunity. I just really wanted to express my appreciation to the committee for this consideration. It's a long time coming. It kind of chokes me up. I know we've been working on this, and it's something that we've needed in Washington County for quite a while. So I really do appreciate everything that the committee has done to work towards this. And now we'll move forward. Thank you.
We appreciate the fine work that Representative Toole and you have done on this legislation. Representative Reckett, you get the last word on LD 272.
Thank you. I have a question actually for Peggy. I think Peggy, because we have voted unanimously, is this bill likely to go into the hopper for next week? No?
No, we have to get a fiscal note on it first. And if there's anything other than cost absorbed, I really doubt that's going to happen. But if it's cost absorbed, so it doesn't need a fiscal note, you won't see it again, but I'll let you know. But if there is a fiscal note, then I'll bring it back, because you will have to look at that and consider it and possibly change it to an ought to pass as amended to include a fiscal note. Or worst comes to worst, an appropriation section.
Thank you. Anyway, I'm really happy, and thanks to everybody who joined all of us in this effort. It's as several have said, it's long overdue. Thank you.
Thank you, everyone. That closes our hearing on our work session, excuse me, on LD 272. Next up is LD 310, an act to establish equitable education requirements for judges. The sponsor is Senator Bailey, and she has appeared magically before us and among us just in the nick of time. So we will start our work session on LD 310 with a presentation from our legislative analyst, and then ask the sponsor for any contributions that she would like to add.
Thanks. The bill itself is a concept draft, and I understand Senator Bailey put it in for the Probate Judges Assembly, and Probate Judge Jared Crockett actually put together an amendment and presented that to you at the public hearing, which would, in the future, starting in January of 2023, require judges of probate to meet all the same judicial education requirements that apply to district court judges and superior court judges within 1 year of taking office. All rules adopted by the Supreme Judicial Court that apply to judges in any state court apply to judges of probate. A judge of probate who meets the judicial education requirements would be deemed to have satisfactorily met the mandatory continuing legal education requirements that are imposed on practicing attorneys by the Maine bar rules. So what this is addressing is that probate judges really don't have a uniform education or training requirement, because each county has its own probate court and each county elects its own probate court judge. And some of them work almost full time, and some of them work, they only need to be in court a few days a month. So some of those days when they're not acting as the probate court judge, even though they're the probate court judge all the time, they can be practicing law. And so that is why I think the bar rule about continuing education requirements that applies to attorneys applies to probate court judges. They are not exempted out of that. At the same time, the judicial branch, although it's not in the statute, requires some education and training for all the judges on the bench to go through. Judges are exempt from the bar rule continuing legal education requirement, as are actually legislators while they're active legislators. So this bill would put into statute. The reason they came forward with a bill is because the Supreme Judicial Court might be able to adopt rules about how probate courts work, but they can't actually direct the probate judges to jump through any kind of education or training hoops. So the idea was to put that in statute, and then that would apply to the probate judges, and then they could be exempt from the continuing education requirements. I threw in some language that was from the Maine Constitution, where the probate judges and registers are established by the Constitution. But in 1967, I think it was, the people in Maine voted to do away with the elected probate judges when the legislature enacts a system that provides for full-time probate court judges. And I know that people talk about there's been constant movement to try to pull the probate courts into the judicial branch, and for various reasons. One is consistency, and I've included the recommendations from what people call the Futures Commission. It was actually commissioned to study the future of Maine's courts in 1993. And it talked kind of about a phased system where you move the judges in and then bring the whole courts into the judicial branch. And so that's what Judge Crockett was talking about as kind of making these little steps in order to unify all the courts. And because it was a concept draft, nobody could really react to that. And since then, Julie Finn from the judicial branch did submit some written testimony in opposition and has information there that was not available at the public hearing.
Thank you. Do committee members have any questions for our analyst? Representative Harnett?
Thank you very much, Madam Chair. Thank you, Peggy. And I quickly reviewed Julie Finn's testimony, and if it's in there, I missed it. But I'm curious if you know, you mentioned that probate judges still can maintain an active private practice in their capacity as a probate judge. Do you know what the comparison is between the CLE requirements for private attorneys under the Maine Bar Rule 5 and judges under whatever they are governed by?
I do not, and it probably isn't, calling them continuing legal education requirements for judges might not be quite the same thing because they don't have to be licensed, but there are education and training requirements that the judicial branch does impose on the judges. I don't know what they are because they aren't established in statute, and I don't believe they're established by order, but maybe if Julie Finn is around, she can explain what those are. And I know there's quite a bit initially. I don't know what there is going forward as a judge, stays on the bench, what's required of them to renew or pick up new issues. I'm sure there's lots of procedural training as well.
Thank you.
Thank you very much. Other committee members, questions for our analyst? Not seeing any. The bill sponsor, Senator Bailey, is here with us. Senator Bailey, would you like to address the committee, and then we may ask you some questions?
Thank you, Madam Chair. Yes, I would like to just address some of the points in Julie Finn's letter, and then talk a little bit about the kind of the interplay between attorney CLEs and judges. First, in regards to Julie Finn's letter, one of the issues she brought up was payment. I don't think this bill is meant to address payment. If there is any payment required for judges training, I think that, like with any CLE or seminar or whatever, that the individual would be responsible for paying for that. Obviously, if there's some agreement with their employer to get reimbursed or otherwise, just like, again, an attorney who has to do their CLE, and some employers will pay for that and some don't. So I don't think this bill is again meant to address the issue of payment. That would be between the employer and the employee. There was some concern about the state doing training for attorneys, and I would just point out that all judges are attorneys, so the state is already doing that. And then I did just want to clarify, there was something in her letter about that there wasn't that much overlap between the state courts and the probate courts. All they mentioned were the home rule cases. So of course there is a district court in any cases having to do with children, including adoptions and guardianships. But in addition, there is also concurrent jurisdiction between probate courts and superior courts for any civil proceedings, equitable proceedings, anything to do with estates, wills, and trust. And in fact, cases can be removed from probate court to superior court, and oftentimes are. These are, just to keep it simple, these are, for example, if someone contests a will or someone is bringing an action because they're alleging that a trustee didn't behave properly. So I just wanted the committee to be aware that there's more interplay and overlap and concurrent jurisdiction between the courts than was set forth in Julie Finn's letter. In regards to the kind of the interplay between Rule 5, which is the CLE requirement for attorneys, and this judicial training, I, like Peggy and Chair Harnet's question, I'm not sure how many hours the state court judges are required to do for training and ongoing education. Certainly, I think that the committee could structure it so that two things. The first is that obviously, yes, if state court judges only do 1 hour a year of CLE, I doubt that's not the case, but let's just use an extreme example, that probate court judges would still have to meet the minimum hour threshold in total, but that the training, the judicial training, the judicial CLE provided by the state could apply towards those hours. I will just share with you, when I was York County Probate Court judge, I know that almost annually I would go to the National Probate Court Judges Assembly, and as part of that would do, I don't even remember, 20 hours of CLE. And I would then just apply to have those CLE hours approved. And most of them were. And so I would think that the same thing would apply here. And that if the probate court judges are doing training with the state court judges, that they then could apply to the Board of Overseers and get approval for CLE credits. And perhaps you need to clarify that in the statute, but I would think that would be the way to address that. And other than that, I'm happy to answer any other questions that committee members may have.
I'd like to ask you a question, Senator Bailey, and it's going to be a bit of a rambling one. I apologize, but my concern, first of all, thank you for bringing the bill forward. I completely understand from a policy perspective the rationale for the bill. When I read through the proposed amendment, I was concerned that it was a very broad brush solution or a broad brush way to accomplish the policy without really focusing on kind of the nitty gritty of what is the judicial branch offering that is useful to probate court judges versus what's not useful. And then what's the amount of non-judicial branch CLE that's appropriate for probate court judges. And I feel like as a committee member, I want to dig into that and come up with an amendment that is more, a little more, has more specificity than the amendment that we've been presented with. But I also kind of feel like we don't have the experience and kind of baseline knowledge about what is offered that might be by the judicial branch that would be appropriate for probate court judges, and to what extent they should also engage in the same CLE that practicing attorneys do. And I just feel a little at loss as to how to sort that out. And I'm wondering if you can give us a little bit more of a suggestion about how to do that, since you are both not only a state senator, but a former chair of this committee and also a former probate judge, as well as a practicing attorney.
I wear a few hats.
Lots.
Yeah. So yes, I mean, I think that it's appropriate for the committee to explore that perhaps the CLE that would be attributable again towards fulfilling this requirement is, that those trainings or CLEs that either have to do with being a judge in general, you know, courtroom demeanor, rules of evidence, just anything to do with being a judge in general. And then secondly, anything that has to do with any areas that there is concurrent jurisdiction. So for example, I could see where, yes, a training for, you know, a probate court judge to, you know, how to pick a jury in a criminal trial may not be applicable. But there's so much concurrent jurisdiction with both the district court and superior court that I think there's going to be a lot of opportunities. And again, I would say that at least in the past, those trainings that I've attended with the Probate Court Judges Assembly have generally been approved for CLE credits as an attorney as well. So that would be my solution in terms of, you know, having the Board of Overseers make that call in terms of, does this training, does this CLE qualify towards attorney CLEs? I mean, they do this all the time. You know, you go to a seminar that hasn't been pre-approved, or you go to a meeting and you send in your form and say, I think I should get an hour credit for this, and here's why. And sometimes they say yes, and sometimes they say no. So that's how I would address that.
Just a clarifying question, the probate Judges Assembly that you described earlier, that's a national organization. It's not something that's offered by the main judicial branch.
Correct. I was just using that as an example of, you know, it was specifically judicial training, if you will, because it's just probate court judges from across the country. That then I and others would apply to the Board of Overseers to get CLE credits towards my attorney license. And they would look at the syllabus and look at, you know, what was discussed and approve those hours or not. And again, more often than not, they approve them all.
Yeah. And this is actually kind of asking for something kind of the opposite of that in a lot of ways, because it's relying instead on training that would be provided by the main judicial branch rather than by an outside organization. And I'm just wondering, it seems like at this point there isn't probate judge specific training that is offered by the judicial branch. Am I understanding that correctly?
Not that I'm aware of. Certainly and Judge Crockett can speak more to this, but certainly the main probate judges assembly, you know, they meet and they discuss cases and they do things like that. But no, there's no training from the judicial branch for probate court judges. And that's what we're trying to address here.
Thank you. I've monopolized a lot of your time. Other committee members, are there questions for the bill sponsor? Okay, I am not seeing any. We will, if you're fine to continue to participate in the meeting, we'd appreciate having you here. And at this point, great, we're gonna go to the attendee list and ask, we'll bring folks in one at a time. I guess at this point, what I'll do is move in Ms. Finn, and then we'll move in Jared Crockett shortly thereafter. We'll take people one at a time. Hello, Ms. Finn. Welcome to the Judiciary Committee. I think we've have had a pretty good review of your written materials, and so I think at this point I might just open it up, if you're okay with that, to questions from committee members. Is that okay with you?
Certainly. I did submit the testimony yesterday. I believe the committee gave me permission to present it today. I don't feel the need to read it. But if anyone has questions, I would happy to answer those. The judicial branch does oppose this bill, and it's just mostly due to the fact that probate judges are so unique in the fact that they're part-time judges and part-time practicing attorneys. And the Supreme Judicial Court feels that it's important. The CLE rules for attorneys are important, and no other group of attorneys has exemption from that. And there are a lot of differences. But with that, I will stop and answer questions from the committee.
Thank you. Committee members, I see a question by Representative Moriarty. And again, welcome to our committee and thank you for being here today, Ms. Finn. Go ahead, Steve.
Thank you, Madam Chair. Ms. Finn, a couple of questions for you. I'm not really sure what constitutes a program of instruction or whatever for members of the state bench, but I take it that such programs are given periodically during the year, maybe once a year. Can you just elucidate on that a little bit?
Yeah, thank you for asking that. And Representative Harnett had asked a similar question, I think, about what do the state judges do in terms of continuing judicial education. And it is all done in-house, and it is about the same in terms of credit hours. It's 24 hours every 2 years, and attorneys have a requirement of 12 hours every year. So it amounts to about the same thing, and it is done in-house on a myriad topics. I think others were talking about what percentage would be relevant to probate judges. I don't have that information offhand, but as you know, the district and superior court judges hear all manner of cases from basically every type of law.
Okay, so let me follow up on that if I could. Suppose that this in-house training contains, among other things, a presentation on judicial ethics or possibly the challenges presented by the pro se litigant. Would the department have any objection to probate judges attending programs of that type?
So you're asking if in the limited circumstances where the subject matter of the training would be relevant for probate judges, if there could be sort of a partial sharing of training?
Well, I'm asking whether the subject matter is universally applicable to both members of the bench and to probate judges, as in ethics and pro se litigants. Would you mind if they attended? I'll just stop there and may have some follow-up questions to add.
Well, that's hard to say. I think that the Supreme Judicial Court is the entity that oversees all attorneys. And as such, that the decisions about the training, with all due respect, should probably reside with them. I can't say exactly, not being familiar with the detail of the training programs and the subject matters, whether a sort of partial sharing of training would be permissible. There is training available for attorneys, and as Senator Bailey talked about the National Probate Judges Assembly, which sounds like I don't know anything about that. It sounds like something that would be extremely relevant to them.
I'll stop there. Madam Chair, I do have sort of a framework to offer for discussion, but I won't do it now because I'm sure other people have their hands raised, and I'll wait.
Oh, okay, thank you. I think Representative Harnett was next.
Thank you, Madam Chair. Representative Moriarty asked most of the questions I wanted to ask, and I understand from Ms. Finn that she's not certain whether or not the Judicial Department would want the probate judges at their trainings. That hasn't been decided yet. But I'm curious as to, one of your concerns was exempting the probate judges from the requirements of the bar rules. And Representative Senator Carney talked about, sort of a hybrid approach where they could use some of the training from the Judicial Department, but that in and of itself, one, it would have to be applicable to what they were doing, and two, in and of itself, that would not be enough to satisfy the bar rules, but could be credited to that. And I'm not saying this as articulately as I'd like, but would that lessen your opposition to this proposal if they were still required to meet the 12 hours a year that the bar requires, but they could apply some of the hours that they got from judicial training?
I think that is a better situation. And I can't speak to whether the Board of Bar Overseers, whether they accept credits for out-of-state probate judge training or not. I would hope that, I think Senator Bailey said they frequently do. Part of what's difficult is about this, having state and probate judges trained together, is that one day there could be a judicial training, let's say it's entirely on topic, with Superior Court and District Court judges and probate court judges. And the following day, that probate court judge could be in court in front of one of the district or Superior Court judges in a case. And they could, make reference to the fact that, oh, we were in training together yesterday, which the other attorney and the other party, might find objectionable. And that, I don't know how to, maybe uncomfortable situation is something that is of great concern to the judicial branch.
May I ask a follow-up on that, Senator Carney?
Yes.
Private attorneys serve with judges on committees all the time. You have the JAG, there are various committees that have members of the bench and members of the bar. Do you have the same concern about them appearing in front of the judge the next day?
Well, I think training that's directed toward, I feel like the training situation is different from committee work. Committee work is generally a collaborative effort between the bench and bar. And I am aware of several committees such as that. I think the sharing the training, I do find that where they're all sort of in the same category of, for lack of a better word, trainee or student or person who's receiving this education, rather than a group of professionals that are all on a committee together.
Thank you.
With your indulgence, Representative Reckett, I would like to ask one follow-up question related to this as well. So is the concern that the training is on the subject matter of how the judge is going to run the hearing in the courtroom, and the attorney who is a participant in that hearing has been in the training session and kind of heard what the attorney is practicing before, has been trained to do, and that's the unfair advantage?
Well, I think that could be, I hadn't actually thought of that, but I think that could be one factor that could skew toward perhaps advantage to someone who'd been in the same training. So that I think that's a factor, yes.
It's different than the committee situation because of the subject matter. Thank you. Representative Reckett?
Well, I've had a lot of interactions with the judiciary, many of them around training issues, and I'm quite aware of the fact that the training for the judiciary varies from year to year widely. and often is connected to whatever the judiciary itself or the Chief Justice et al. See as the priority for the judges to understand. I've been involved with several training days with judges where I was asked to present, occasionally when I was allowed to attend, but it's been very rare that people were allowed to attend judicial trainings. I think there's a sense that there's very few times in the whole universe of the year when judges are allowed to be together by themselves. And I think that that's not a bad thing in my view, because I think it gives them a chance cross jurisdictions to flesh out whatever the issues are that they're dealing with the same all over the state, or that, and I think that there's, as last time I checked, darn near zero training money to do any of this in the judiciary. The times that I've been involved have been in trainings that, frankly, I helped find the money for the judiciary to have a training, and sometimes wasn't even allowed to be in it, but just to provide the resources. But I think it's really important that the judiciary be allowed to set up its own training modules based on what they're seeing in the trends and needs of the judiciary in order to do their job. And although I would have, when we started this conversation, been more in line with the thoughts of the bill, I have shifted back to my traditional view that the judiciary, that is district superior and law court, have different needs. And I think that it's important that we let them set their own training agenda, frankly. And it may be that they will have something that I can see it like an ethics piece or something else that might be of universal interest. I can't imagine they wouldn't open that up if that was the case. But they might not, because they might be wanting to talk about their own internal ethical issue stuff. And I don't know that I would want them to have to share that. So I'm sort of not in favor of this bill, I think. That's where I've landed here.
Thank you, Representative Reckitt. Representative Libby, did you have a question for Ms. Finn?
So my question might be a bit elementary. I have been coming at this from the understanding of what my continuing education requirements looked like as a nurse, which was there were all these different modalities. You could do it independently, and many, many, many different routes through which you could get your continuing education credits. It sounds to me like I'm coming at this from the wrong direction, and that's not quite how it works for the judicial branch. So I guess I would like to have a better understanding of how it does work. And the other piece of that is that in my understanding of this bill, it was more about having the same standard for probate court judges. But am I correct in that it is more of taking the same trainings with the district court judges and superior court judges that is the issue that Ms. Finn is bringing up? Sorry, that's a lot there. I'm not sure how to unpack it more easily.
Well, in terms of the beginning part of your question, you talked about the different modalities for training. I think that is absolutely true for attorneys. It's not true for judges, however. For the state court judges, really the training is in-house. There is a National Judicial College, which is out in Reno, I think, and that's, expensive and a thing we can't really afford. So training does tend to happen in-house. And occasionally, as Representative Reckitt mentioned, subject matter experts might be invited in on a subject such as domestic violence or the like. So it's limited. The options for judges for training are limited. And they do serve on panels on occasion with lawyers during CLE programs where different types of law are discussed, but the judges aren't sitting in the audience as part of the class. And that, it's just it's a different role. It is, it's difficult being a judge. It's difficult being the one sitting on the bench and having to make the decisions. And it's really having their training be something that is separate and is part of their program, I think is important to them. Whereas attorneys, you can do online things, you can get written materials and review those for CLE, you can go in person, you can watch a recording of something that was in person. There's just multiple ways to do it, but that's just not the case for judges. And if I could, I would also, like to mention there has been a lot of discussion about the probate courts and the state courts and doing some whether, as you all know, Representative Cardone has a bill to create a commission to look at ways that things could be combined beyond the Home Court Act. And we have not taken a position on that, but that is a place where I'm sure a lot of these issues will be hashed out if that bill passes.
Thank you. That was very helpful.
Committee members, are there other questions for Ms. Finn? Okay, I think at this point, what I'm going to do is I'm going to move Ms. Finn back to an attendee and bring in Mr. Thank you for speaking with us this afternoon. And let me see, my eyes are getting tired. There you go. You're back as an attendee. And Mr. Crockett, I think that you're in the process of joining us.
Yes, do you have me now?
You are with us visually and audibly, so you may, let me see, did you prepare remarks that you wanted to give to us this afternoon?
No, I submitted testimony originally, but there is some clarifications that should probably be offered.
Okay, why don't you go ahead and offer those clarifications, and then we'll ask committee members if they have questions for you. So
Okay,
go ahead with your clarification.
Some of the points that were raised earlier in terms of judicial education. Senator Bailey, obviously former Judge Bailey, hit the nail on the head in terms of there is a specific probate judges college nationally. And we also have our state assembly where we do a lot of our trainings. That being said, there are a lot of, as Representative Moriarty alluded to, there are a lot of trainings that are uniform to all courts. All courts in the state deal with rules of evidence, civil procedure, how to deal with pro se litigants. There's the operations of a court. One of the things that the Judiciary Committee has been charged with in the past is trying to find uniformity between the probate courts and the state courts. That's the spirit of what this bill is trying to get at. Now, the issue is, as it always has been, is the judicial branch is really unfamiliar with the 16 judges that comprise the probate courts in the state. Some of them are essentially full-time. When Judge Bailey or Senator Bailey was a judge, she was 3 days a week on the bench, plus the hearing calls on the other 2 days when she was practicing. Cumberland County has almost a full-time probate judge. Some of the probate judges are actually exempt from CLEs anyway because they've been practicing more than 50 years. One of them is a professor at a school, as well as being a probate judge. So she's not a practicing attorney. So there's that issue, but there's also the question of, do you want probate judges to be in a silo? Each county has its own chief judge, essentially. Now, we have a lot of jurisdictional overlap with the judicial branch. We apply the same rules. We have to run our courts in the same way. We have equitable powers that deal with property that stems from estates. One court has a $40 million estate in it. And there's a lot to be dealt with in that. This isn't, it's a constitutional court, and it's sometimes confused with the fact that the district and superior courts were created much later in the system. So that's why the laws kind of read as they do. The superior court didn't come about until 100 years after the probate court. The district court wasn't until the early 60s. So a lot of those overlapping jurisdictions, the judicial branch and the current crop of attorneys aren't really familiar with the probate courts unless you practice in that area. Some of the attorneys, I'm sure on this esteemed committee, have had practice in both probate courts and the state courts, and they're supposed to run the same. But the bar comes back to us and says there's issues that some of the probate courts aren't. So that's why we came forward with the bill. The issue of how to deal with our colleagues on the district court bench is no different than legislators. When I was a legislator, I don't know how many judges I've appeared in front of that I had to be on their vetting process before they became judges. That wasn't awkward for the judge, and it certainly wasn't awkward for me, because he would have ruled against me, he or she would have ruled against me or for me based on the merits of the case. So the fact that some of us are practicing part-time in order to offset how low the county can get away with paying probate judges is not really the issue. The issue is, how can we get our courts to run more uniformly? The body of law, a lot of these judicial, like my predecessor had a master's from the Judicial College in Reno. The issue, and that's the college works for any type of judge throughout the nation, whether you're dealing with criminal, probate, whatever. There's an establishment of how to run a courtroom, how to establish the records. That's what we really need, because eventually, if the committee is going to take an action, this commission that Representative Cardone is proposing is just a step in that direction. But there's a lot of details that will have to get worked out there.
I'm going to interrupt you there, Mr. Crockett, because I see that we have some committee questions, and so let's move on to those. And thank you for raising those issues. Representative Libby, you may go ahead.
Thank you, Madam Chair, and thank you, Judge Crockett, for being here. My question is, I understand the desire for uniformity and that this bill is intended to help do that. My question is, if a probate court judge was not practicing currently as an attorney, would they have any continuing education requirements as a probate judge?
No,
Okay.
like we have some judges who don't.
Okay, thank you.
Are there other questions for Mr. Crockett? Representative Moriarty?
Judge Crockett, you've really hit some good theoretical points here, most if not all of which I agree with. I'm just wondering how important it is that attendance at programs through the judicial department should fully satisfy a probate judge's annual CLE requirements.
It is going to be a hard, in the process of trying to get 16 different counties on board with a particular change of this magnitude, there were certain compromises that had to be made, because there's always the argument, as Representative Rickett raised at the hearing, of cost, how it gets divvied up, because the counties can always raise their hand and say, hey, there's a fiscal note here, you're requiring us to send judges and therefore mandate, and then it's a different ballgame. So that was part of the compromise, the making the sausage to get this through. I want to put not every probate judge in the world or in the state of Maine necessarily is in tune with this significant a shift. We did get a majority, and so we felt we could bring the bill forward, and Senator Bailey was so gracious to do it for us. But we're trying to make steps gradually, because as you have personal experience with how changes to probate court can die a very painful death anytime there's attempted reforms. And so we're trying to get there. I understand the judicial branch doesn't want this, and it's going to be a problem with any reform we have. That was fully expected, because it has always been the case, because there's cost and there's adjustments that have to be made. And the legislature is going to have to direct if there is ever going to be a change, even over the objections of both the probate court and the judicial branch. That is going to have to be the role. There's going to be no, hence why since 1967, there's been no implementation. So I leave it in your capable hands. And again, it's not a live or die bill for the probate judges. We're just trying to help with what the Futures Commission had. So
Okay. You've told us how busy the Cumberland County probate judge is, and I think the answer to my question is probably obvious, but that must vary widely all around the state based upon population primarily. In other words, the number of hours per week or days per month that you actually wear the robe must vary quite a bit.
Yes, right now, Judge Mitchell, Libby Mitchell in Augusta, she's probably on the bench 2 or 3 days a week, and then she's dealing with the administration of the court because we're all the chief judges of our respective courts. You can imagine if you had 16 different chief justices working in a silo, how far off the operations of your court can become from one uniform way of operating, which is going to make it even harder on the state if they ever are to take the the probate code courts. So I'm sorry.
Okay, thank you.
I would like to ask a question. You mentioned earlier that the bill that you presented to us, the amendment, was a compromise among the different probate court judges. And so are you suggesting that if we enacted something different than your proposed amendment, that it would be unsatisfactory to the 16 probate court judges?
I don't think any probate judge would ever dare to step on the great knowledge and wisdom that rests within that judiciary committee, especially with Peggy and Soupy being present. But I will say that if, depending on what comes out of the committee, in the past, and many of you have seen it, there's been other information that's come out, and the court, it's not just the probate courts. There's county commissioners involved here too. That's why this is such a big deal. It's not a small shift. And that's one of the reasons why nobody wants to touch it and nobody wants to open up that Pandora's box. And that's why we have opposition to it every time. So I'm not saying that they're going to oppose whatever the committee comes up with. I think everybody in the legislature will contemplate with great diligence whatever product this august committee comes out with, and then deliberate and figure out whether they're for or against it. So.
And then one final question. Did you have conversations with the judicial branch regarding the amendment before you presented it to us?
No, I did not have any great deep conversations initially, and I think I can disclose all of this. We have a liaison from the Supreme Judicial Court. We got Justice Connors, who seems to be she seems to be very great in terms of dealing with her. She's new to the court, so we're kind of getting her spun up on the probate court piece. Justice Gorman was our liaison for some time. So we talked initially about the concept, but the problem is the judicial branch can't mandate this change. Because we are a constitutional court, it has to come to you. Now, I did provide my testimony to Attorney Flynn prior to the hearing because that's only due and proper. So that way they'd have some basis but there was no great discussion because there can't be without some direction from the legislature. We bow to your lawmaking authority.
Thank you. Representative Reckitt?
I'm sitting here trying to digest the fact that I think I heard, and somebody stop me if I'm wrong, that Representative Cardone has a bill in that would mandate a study and a movement forward in a rational manner altogether towards this goal. Did somebody say that? Did I dream that? Or, I mean, why would we not do that if that's, because it seems to me, I mean, if we did that, it would indicate that we wanted to move forward in the conceptual integration of the courts in a way, but we could do it in some kind of methodical way. I'm not sure starting with this concept we have before us today is the way to start, but I can see it as a step along the way. But I would want to have a baseline vision for where we're going and how fast. So that's my concern.
Thank you. Committee members, are there any other questions for Judge Crockett before we move on to our committee discussion? Not seeing any hands raised. So Representative Moriarty, you had your hand raised earlier, and not even sure you're still with us actually, but do you have a question? Okay. Judge Crockett, we are going to move you back on to the attendee side of this meeting across the virtual committee room, as it were, and we'll initiate our committee conversation. Thank you.
Thank you for your time.
Thank you so much. Committee members, we've received an indication from Peggy that the item that Lois was referring to is LD 719, a resolve to establish the commission to create a plan to incorporate the probate courts into the judicial branch. And that we can't debate that today because that resolve is not before us. It has not been duly noticed as a public hearing. We know that that will be on our plate later this session, but it's just not with us right now. And so let's engage in a discussion and or a motion pertaining to the bill that we are currently on. And Representative Harnett, you have your hand raised.
Thank you very much, Madam Chair. And I'm confused as to where we are procedurally. We had an LD printed that was a concept draft. We have a proposed amendment from Judge Crockett. And maybe this is a question for Peggy. Is that the LD that is in front of us now? I mean,
So anything you do with this bill would have to be by a committee amendment. So you would, if you wanted to go forward with this, you would vote ought to pass as amended, and the amendment strikes out the concept part and puts in the details.
Okay, well, as to the amendment, I have, I'm concerned that it doesn't provide enough meat on the bones. I'm concerned in the first sentence, it talks about the probate judges meeting the legal education requirements of judges within the first year that they serve. And we heard from Ms. Finn that the judges have a 2-year cycle for earning their legal education credits. I'm still not clear on how many of those credits would be worthwhile to probate judges. But I also recognize that private attorneys can take CLEs on anything, even if it's not an area they work on, if it's, approved by the Board of Bar Overseers. But I just can't see moving forward with what we have in front of us today. So that's where I'm not sure where we are.
Thank you, Representative Harnett. Representative Moriarty, did you wish to speak?
Yes, I do. Thank you, Madam Chair. And I agree that we're probably not poised to move forward. What I want to do is just offer a framework for further drafting. And this depends in large part upon the goodwill of Judge Crockett to continue with his drafting, if my suggestion has any appeal to him. Just a few parts here. First of all, I think that probate judges should continue to satisfy the continuing legal education requirements annually, as is the case with all active practitioners, all of those who are actively licensed to practice law in the state. Second point is that I believe that the probate judges ought to be able to attend educational programs offered by the judicial branch for their own members, which have applicability or jurisdictional overlap with the work done by probate judges. And I mentioned the area of ethics and the problems with the challenges of pro se litigants, but I may be understating the commonality between some topics. And I think that a probate judge attending a course offered by the department ought to be given CLE credit. Sorry, they ought to receive CLE credit for attending the courses offered by the judicial department, but that they otherwise need to make up the rest of their hours elsewhere. And that recognizes the fact that probate judges are, in most cases, practicing attorneys and may have a practice in real estate or plaintiff personal injury law or something like that, in which they're occupied when they're not serving as judges. So that's the kind of the framework that I'm suggesting. I'm not concerned about the physical presence of probate judges in the same room as members of the department attending the same educational program. There are occasions when the members of the bar and judges overlap socially, as in panel members at continuing legal education programs or the summer and winter meetings of the Maine Bar Association, and yet may face each other later on that same week in court. That's not really an issue for me at all. So, and then finally, I guess, the question is, who is to be the arbiter of whether or not a judicial department program, in fact, can be relevant to a probate judge and can count toward that probate judge's annual CLE requirements. And I can tell that the court system itself doesn't want to get involved in playing that role. And I guess I would suggest that the Board of Bar Overseers be the arbiter. And to be more precise, if a probate judge wanted to attend an upcoming program offered by the department, the burden would be upon that judge to seek pre-authorization from the Board of Bar Overseers that such attendance would in fact count towards satisfaction of that person's annual CLE obligation. So if Judge Crockett is willing to take that and run, I agree we're not really ready to do anything today, but perhaps if this could be put on paper, we'd be in a much better position.
Representative Rackett? We're not able to hear you, Lois.
I have a question not for Representative Moriarty or for Judge Crockett, but for Representative Newell, if she knows the answer or would be willing to figure it out. Is there any analogous, I know what happens somewhat in tribal courts. Where do issues that we would characterize as probate issues, where do they land vis-a-vis the tribes? Do you deal with that internally, or is there a usage of the current probate courts?
Thank you for the question, Representative Rackett. If I were to recall, I do believe that probate issues are covered within our tribal court.
Okay.
I could certainly reach out and verify that.
And I would just really want to know that before we leapt into some, coordination of all the courts on the state side. I'd want to make sure we weren't tangled up in the wrong way with tribal courts and that issue. So that's all. Thank you.
I'd like to share my thoughts about this and express a lot of appreciation to Representative Moriarty for a suggestion of how to move forward. I personally am feeling appreciating the policy objective of us finding some kind of uniformity, but I am also quite concerned that I am concerned about us as the legislative branch essentially directing the judicial branch to open up their judiciary-specific training to the probate court judges. There's, I am not inside of that system of how the judicial branch operates its training. And I feel like I lack the perspective to really evaluate totally whether it is appropriate to extend that training to probate judges at this time. I am glad that we will have another opportunity to look at kind of the role of the probate courts and the judicial branch. I guess I personally am reluctant to move forward with this when there are so many unanswered questions about that relationship right now. Other committee members have thoughts that they'd like to share? Does anybody have a motion they would like to offer? Representative Libby?
I move ought not to pass as amended.
Is there a second?
Second.
Representative Reckitt has seconded. Discussion, and I know Representative Moriarty, I was just going to call on you because I knew that you, I saw your physical hand as well. Go ahead, Representative Moriarty, and then Representative Libby, and then Representative Harnett.
I will pass for the moment. Thank you, Madam Chair.
Representative Libby?
Thank you, Madam Chair. I appreciate the intent of this. I don't have the history that so many members do of having been on the committee and seeing the push for uniformity. My only hesitation in on not to pass, which is my motion, is that understanding that there are no education requirements for probate judges if they are not also practicing as an attorney. So I think it would behoove this committee to address that at some point, but I don't think that this bill at this time is that solution.
Thank you. Representative Harnett?
Thank you, Madam Chair. And I know we're not talking about LD 719, the resolve that is not in front of us that we haven't seen yet, Representative Cardone's bill, but we do know we are going to see it. And I don't know, I'm not certain if the better approach is to hold on to this till we see what happens with that proposal. Because if the ought not to pass motion moves forward, then this is off the table. The discussion of this training for the probate judges is off the table. So I just put that out there.
Are you going to make a motion to table, or are you not quite prepared for that at this point?
I'm keeping a list of how we're doing today, and the thought of adding another table next to something is not appealing to me. And motions to table are not debatable, so I really can't ask how other people feel.
Okay, let me move on then to Representative Newell, who's
let me think.
Hand up, and Representative Moriarty. Go ahead, Representative Newell.
Thank you, Madam Chair. However, I want to defer to Representative Moriarty because his hand was up before mine.
Oh, thank you. Representative Moriarty.
Thanks very much. In the years I was on the town council, I was trained that you shouldn't spend a lot of time speaking and then make a motion which is non-debatable. So I won't make the motion to table, but I think one should be made. And I think in part for the reasons that Representative Harnett suggested, that something is coming our way which will overlap to some extent with the issue with which we're dealing. I would hate to see this bill put to rest at this point. I think there's more work to be done. I'm not interested in tabling a whole lot of stuff, but that seems to be the way things are going this afternoon, at least. I would hope that someone would make a motion to table, but I won't do it because that would kill debate.
Thank you, Representative Moriarty. Representative Newell, it is your turn.
Thank you, Madam Chair. Based on what I just heard from Representative Harnett and Representative Moriarty, I feel like this discussion should continue. I would not want to see, I realize there's a motion on the table for ought not to pass with a potential second, but I do believe that this warrants further discussion. However, I think there were some instructions that possibly were suggested to one of our guests that was discussed earlier. So, Madam Chair, I would like to make a motion to table at this time.
Okay, there's a motion to table. Is there a second? Seconded by Representative Harnett. It's a non-debatable motion. And because we've been recommended to do these motions, to do all of our votes by roll call rather than a show of hands in the electronic format, Ms. Panett has appeared before us and is going to call the roll. You may proceed, please, Ms. Panett.
Thank you very much. Senator Carney.
And this is on the motion to table. Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
I was just frozen out for about a minute and a half and was able to rejoin. Can you tell me what's pending? Which motion we're voting on?
Madam Chair, we're voting on the tabling motion.
So there was a motion to table.
Correct. Representative Newell and Representative Harnett seconded.
Okay, then I vote yes in favor of the motion to table.
Thank you. Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
No.
Representative Hagan votes no. Representative Downs.
Yes.
Representative Downs votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos. Representative Newell.
Yes.
Representative Newell votes yes. Senator Sanborn. Senator Sanborn is absent. Senator Keim. Senator Keim is absent. Representative Evangelos. Representative Evangelos is absent. 10 members voted yes. 1 member voted no. 3 members were absent.
Thank you very much, Ms. Panett. So the vote on the motion to table passed. And so LD 310 has been tabled. Committee members, and that ends the work session on LD 310. Thank you very much to the bill sponsor and to all who participated in the work session on LD 310. We have before us 2 more bills, LD 422 and LD 420. I also appreciate that it's pretty late in the day and we've been going for a little bit over an hour and a half without a break. Can committee members let me know how you're feeling about moving forward with the 2 final bills that are on our list for the work session? Representative Libby?
Thank you, Madam Chair. 420 seems to be a relatively simple bill from our public hearing, but 422, I know I will have substantial questions to fully understand it and be able to make an educated vote on that personally.
Thank you for those comments. How do other members of the committee feel? Representative Harnett?
I agree with Representative Libby. I believe we can get through LD 420 pretty easily. And I actually have questions about LD 422 because it was a concept draft with an 89-page reference to a bill, a uniform bill that we're not even sure where it's going to be placed. So I think that is a discussion we could get bogged down in a bit. So my proposal would be to deal with LD 420.
Okay.
And
Yeah, that's a great understatement. Representative Hagan and then Peggy.
Thank you, Madam Chair. I would also agree with Chairperson Harnett. I feel overwhelmed with this one. There's a lot going on, so extra time would be great.
Okay, yeah. Peggy, you have words of wisdom to share with us.
I don't know if they're wise, but what I would be happy to do is take LD 422 and Pat Lack had produced language. I would be happy to put that in the form of a committee amendment for you to consider, get it out to you and you can consider it and we can bring the experts in and you can talk about it more in detail. So if you just wanted to table it and I could, work on it that way, that might be much more productive than trying to work through anything today.
Thank you. So that's a great suggestion. So perhaps we could have open up the work session on 422, move to table it, and then go on to 420, which we all expect to be relatively simple. So if you could just nod your head if that seems like an appropriate, I'm seeing lots of nods. Okay, so we'll open up the work session on LD 422. And I see that Representative Babbage has his hand raised. Are you prepared to make a motion, Representative Babbage?
I move that LD 422 enact the Maine Uniform Trust Decanting Act be tabled.
Is there a second? Representative Poirier, I saw your hand first. Again, on this tabling motion, we'll do a roll call vote. Thank you very much, Ms. Panett.
Ready?
Yes.
Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Downs.
Yes.
Representative Downs votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos. Representative Newell.
Yes.
Representative Newell votes yes. Senator Sanborn. Senator Sanborn is absent. Senator Kime. Senator Kime is absent. Representative Evangelos. Representative Evangelos is absent. 11 members voted yes. 3 members were absent.
Thank you very much, Ms. Panett. So LD 422 has been tabled. Peggy is going to prepare a draft amendment for the committee to review and get ready for when we take that up again. And so that closes the work session on 422. We'll open the work session on 420, which is an act to amend the Maine Revised Unclaimed Property Act, sponsored by Representative Riley of Westbrook. And I will move him into the panel if our analyst would like to begin to present us with the analysis of the bill. Thanks very much, Peggy.
Sure, thanks. So this bill addresses 2 things that are only together because they're both in the Unclaimed Property Act. And the first one is it addresses fee restrictions on what are called stored value obligations. And the interesting thing about how these are regulated in state law, the only place you can find it is in the Unclaimed Property Act. So even though it really doesn't have anything to do with unclaimed property, this is the only place the state deals with stored value obligations. So that's where the restrictions on fees are in the Unclaimed Property Act. So this bill amends the limitations on the fees for the issuer of, it's actually issuers and acceptors, I believe, of stored value obligations. It allows, right now, there are only fees that are allowed for the initial issuance and for each occurrence of adding value to an existing stored value obligation. So these are reloadable cards, gift cards, accounts. The fees have to be disclosed. And what this bill does is it says those fee restrictions, you can only be charged those fees when you initially load it or when you reload it. Those restrictions do not apply to any stored value obligation that enables the holder, that's you, the consumer, to transfer the underlying fund. I believe that's what the holder is in this case. Transfer the underlying funds to multiple unaffiliated merchants at the merchant's point of sale terminals or online or at an automated teller machine. So it's how you use that card. So that's section 1. And the testimony was that if the banks and the issuers of these cards can't charge those fees for those types of transactions, then they probably will not be offering those as things that consumers can use. That's section 1 of the bill. Section 2 is completely different. This really does deal with unclaimed property, and one property is unclaimed.
Peggy,
And it's, yes.
do you think it makes sense to take these in chunks since
Yes.
they're essentially unrelated?
Yes.
So let's take any committee questions for Peggy related to the first issue, which is when the fees can be imposed. Are there any questions by committee members? Representative Babbage?
Are fees imposed at the time of reloading or initially based on a percentage of the amount on the card, or is it standard?
This law, I don't believe this law governs it. There might be some federal regulations that govern it. This just requires that there has to be complete disclosure of what those are. So you know when you're initially acquiring that, I'll call it a card.
Thank you.
Other questions?
I would assume that this new sentence that says the fee restrictions do not apply to the other fees that could be charged for these different transactions, that they still have to be disclosed. I would think that that disclosure requirement still applies to those types of fees.
Thank you. Any questions? No, okay. Thanks, Peggy. Do you want to talk about the second aspect of it, please?
Sure. So the second one deals with unclaimed property and property that's being, so the property that's governed by the Unclaimed Property Act applies to is really, we're talking about different forms of money, not actual things. And so it applies to banks, insurance companies, whoever hold accounts, and then there's something that's not claimed by the owner. There's a balance in a checking account that goes unclaimed because the person moved to another state. At some point, that bank the law says you determine that it's abandoned property. And at the point you determine it's abandoned, you report it to the treasurer, who's the administrator of the Unclaimed Property Act. And then you have to turn over the balance of that. And that's when it escheats to the state. So that's a great word that I always love to use because I never get to use it in real life. And so in this case, we are talking about bank accounts, a deposit into or withdrawal from an account at a financial organization. So what the law spells out is what shows that somebody is still interested in that account, in that money, in their property. How does the bank know that they know the consumer, the owner knows that they have that account and they're still interested in it. And so there are kind of indications of interest. And one of them is for an account at a financial organization. When the owner makes a deposit or makes a withdrawal from the account, you know that they're actively involved in that account. And what the statute says right now is including an automatic withdrawal previously authorized. So that might be a fee, a monthly fee for a checking account. It might be your subscription to a magazine that comes out. You make that subscription, you make that payment monthly or every 6 months. So it's an automatic withdrawal previously authorized. You as the owner of that account have authorized that withdrawal to happen automatically. You don't have to go in and click it every week or whatever. Or an automatic reinvestment of dividends or interest. So that's talking more about like a CD where it earns interest and it can roll over automatically, or the interest in your account, in your checking account, which is infinitesimal now, automatically. That this section, paragraph E, is saying anytime those happen, we're counting that as the owner of the account taking an active interest in that account. So it's not abandoned. If those things are happening, it's not an abandoned account and it's not unclaimed. The bank just has to keep maintaining that account for that person. What the bill does is it says, right, anytime you make an active deposit or withdrawal, that is actual interest. But it does not include an automatic reinvestment of dividends or interest or an automatic withdrawal of disclosed fees, which means that the bank would not count the automatic reinvestment of dividends as the owner being actively involved in that account, or the withdrawal of disclosed fees. So your magazine subscription, I think, still counts, but not the fee that the bank charges.
Can I just ask a clarifying question? So if I have a bank account that has $100 in it and I have abandoned it and I completely forgotten about it, and I have to pay every month in this forgotten account, I am charged a $5 fee, customer service fee or whatever, then those automatic $5 charges that are happening in the account that I've totally abandoned would not be taken as indications that I'm still actively managing that account, or
that's what this bill would do.
Interacting with it. Okay.
Right. And there was some testimony that this was an inadvertent language when the whole new revised Uniform Unclaimed Property Act was enacted in 2019. And the bill was printed, as the uniform law was printed similarly to what this is proposing, that except for an automatic withdrawal previously authorized or an automatic reinvestment of dividends or interest, was not an indication of the owner being actively involved. But the committee amendment changed that. And the committee amendment changed it to this specific language that you see without the underlines and the strikeout. And so it changed it to except for to including. And the summary of the committee amendment is this amendment revises the bill to provide that automatic withdrawals previously authorized and automatic reinvestments of dividends and interest are included as an indication of an apparent owner's interest in the property. So perhaps, I mean, that the legislature purposely made that change. I'm not sure if when the legislature was purposely making that change, they intended to include those fees that you were talking about, Senator Carney, or not. And I know that that change was made at the request of some folks that had worked there was an interested parties group that worked with the treasurer's office. And so the Judiciary Committee considered that and accepted that change. So I just think, I'm sorry?
When was that change?
This was in 2019. They every
last year, essentially.
Yes. Was it last year or the first year of the the first year of the 129th.
Okay, thanks.
And I raise that because I know that there are some folks, although they didn't speak at the public hearing, there were some folks that have since raised a concern about the change in Section 2.
Thank you. Representative Harnett?
Thank you. I have a question and then a follow-up to what Peggy just talked about. Just if I have a 10-year CD, I open up a 10-year CD, and with the interest being reinvested as it accrues, and I don't do anything other than that for 10 years, for the term of that CD, is that going to a sheet to the state, or are we talking about after the term expires and the lack of indication of interest?
Right. I would expect it's after the term. It's certainly right after the term expires. There's also, and I think somebody from the treasurer's office might be best to explain exactly how they look at that and how they expect financial organizations to look at that.
I'm sorry. And the second thing I would add is I was contacted by advocates for the Credit Union League that had expressed some concern, but then after review and consultation with their members said they no longer had a concern. Okay. But they are both here today. If they do want to weigh in, I would invite them. You know, I know they're in the attendee room. If we get to that point, they could raise their hand to respond.
That would be helpful, Tom. We'll bring them in. Could you give me their names, please?
Ed and Kate Pinot. I think they might be listed under.
I see.
They're Kate and Ed.
Kate and Ed.
Let me take a question. Representative Babbage has his hand raised, and then we'll draw in some other folks to answer questions. Go ahead, Representative Babbage.
Thank you, Madam Chair. I had a note here. I think the treasurer said this was omitted as an oversight, but I'm not understanding exactly where we are here. The Section 2 seems to me that we have a situation, let's say with a savings account, where you either let fees draw down the account, or as I see it, the consequence of not permitting that would be that at a certain time, and I can't recall what it is, although I should, that it would move to unclaimed property. Is that correct? After 2 years or whatever of being
right, and that might be what they're trying to clarify, that these fees that are automatically imposed shouldn't be seen as the owner's active interest, but instead at some point you stop that. So the value of that property is still theirs, even though they don't know it.
Right.
And once it gets turned over to the treasurer's office, you can still claim it. And if you haven't been to the treasurer's website to look at unclaimed property, it even identifies it by address. There are maps to identify unclaimed property by address. If that's your property, you still have a right to go to the treasurer and claim it. So it's actually in your benefit if you have forgotten about it, for the bank to stop doing their automatic fees and instead turn the property over.
My question, Peggy, really is, as I see it, part one, which gets rid of fee restrictions, is not consumer friendly, whereas part two is consumer friendly because it maintains the account without the bank being able to draw it down. Part one, if I just gave my grandson an Amazon card, part one allows Amazon to charge him every time he uses that card in order to make a purchase. Isn't that right?
No, yeah, maybe. No, actually, I think these are intended to be when they are, you can use it at multiple unaffiliated merchants. No, maybe it, I'm sorry. That language is confusing to me. And so maybe if somebody from the treasurer's office could help explain that, that might do us all some good.
Good next step, because I think it's confusing to me too. I can't sort it out, but Mr. Chetkaskis, that is your name. I'm sorry if I'm mispronouncing it. I sense that you can clarify this.
Yeah, that's a pretty good job. Thank you, Chair and committee. So with the stored value card, it's a very broad explanation to or obligation to different types. And so what the change is looking to do is for those cards, like your Amazon card, it could be your Dunkin' Donuts coffee card, those type of cards, they wouldn't be allowed to charge any fee outside of the activation. So when funds are applied to those cards, what it does open up to is more of banking cards or open-ended cards where you see the Visa debit cards, or you go to TD Bank and you purchase a debit card there where you put $100 on it, and then you go to use it at retailers. In order for those banks to be able to conduct that activity, that there would need to be some way for them to recover costs. So there are fees that are with those types of cards or other medias. And so this brings the statute back to kind of the original unclaimed property statute before the 2019 change, which allowed it for those pre-funded bank cards to have fees charged against them, which could be a dormancy fee or an ATM fee, and it really depends on the card brand, and they do need to have those fees disclosed within contract when you purchase that card. So the purchaser of them would know what types of fees would apply for that specific card type.
Could I ask you a question?
Sure.
So this strikes me as something that has impact across state lines. And is there a concern that consumers in Maine would not have this product available to us if we did not enact the first part of this legislation?
That is a concern that the Treasurer's Office has heard, that these types of cards would potentially, if the financial institution decided not to, would not be available to consumers if they couldn't charge the different fees that allow them to manage having those cards in the state. And my understanding is at one time that did happen, unfortunately, within the state of New York.
And so would they not be allowed to be sold in Maine, or would they not be allowed to be used in Maine?
That's a good question. I'm not 100% certain. I know for sure it would be sold. I don't know if they have a way of preventing the use in Maine.
Okay. And so that again would be like a Visa card that you maybe would buy and load up with some money and give it to somebody for a high school graduation gift.
Yeah, kind of like they're treating the card as a bank account.
Okay.
As opposed to a true gift card or stored value as you're using it with that one merchant.
Okay, thank you. That helps me understand what's going on. Committee members, does that help others get oriented to what we're talking about? Are there additional questions for Mr. Chetkauskas? I'm not seeing any raised hands. Are there additional? Oh, go ahead, Representative Babbage, and then actually, Peggy, your hand is raised. Why don't you go first?
Well, I just wanted to double check. I mean, I'm confused by that language. I wanted to make sure that we really are talking about a card that can be used at multiple merchants. So that's why it rules out Amazon, unless you can use Amazon at other. Well, those are gift cards, right? Well, they are reloadable though.
They are. Yeah.
They can be reloadable, so they fall under the definition of a stored value card, but it is a single merchant of Amazon, and then Amazon provides the platform for different merchants, but it falls under one. So it would fall into the first part of that statute, okay, where they would only be able to charge for additional funds added.
Okay, but so it would, a card would have to be accepted at multiple unaffiliated merchants. So Sierra Trading Club and TJ Maxx and whoever those other affiliated, they're affiliated. So that's still more like the Amazon card than like the Visa bank card, right?
That would be correct.
Okay. Thank you.
That's helpful, Peggy. Thanks. Representative Babbage?
Yeah, thank you very much, Madam Chair. I understand what you're saying about Amazon, or if it were LL Bean or something like that, but I don't actually see that in the bill. I mean, a stored value obligation, does it specify multiple merchant anywhere?
The new language does.
Yeah.
The new language does.
The new language is saying there aren't fee restrictions, or those fee restrictions don't apply to these cards that are usable at multiple merchants.
Unaffiliated.
Right,
yeah,
unaffiliated.
Unaffiliated merchants.
Gotcha. Thank you.
Other questions?
I have one more.
Peggy, go ahead.
I'm just wondering if holder is the right word there. Because in the unclaimed property context, we usually talk about the holder being like the bank or the insurance company that has the property that's owned by somebody else. And here the holder, I believe the holder is the owner of the card.
So to clarify, the holder would be any business or entity that has funds that belong to another individual. So if you think of a card, oh, sorry, must be car insurance, warranty. So if you think of the holder would have the card, and it would sit on a system that says X amount of funds for this account number. But the person holding that card would be the owner. So that it wouldn't be the holder, it would be an owner of that card that has the rights to those funds that are held within that financial institution.
Okay, so the holder in that last sentence is actually this entity that maintains the account for the owner. And it's not the owner that's transferring the underlying funds. It's the entity that issues the stored value obligation.
Right.
Okay. Thank you. I'm sorry to monopolize the time.
Your questions, I think, are helping us lead us all to a really clear understanding of the bill, actually. So with a lot of appreciation, Peggy. Committee members, are there additional questions?
Yes, please.
Go ahead.
So the 129th purposely made this decision to not do this. Is that right?
Are you?
I don't think the 129th discussed this issue about stored value obligations. I might be wrong, but I don't think it was something that the committee went in and changed.
Okay, and we've heard from no consumer organizations.
Hang on a second, Chris, because I think there might be another answer or a supplemental. Mr. Chetkakis, did the 129th intentionally change this?
So I don't believe that there was any intention to this. What actually happened is the old unclaimed property statute had pre-funded bank cards, which are these multiple affiliated merchants cards, and stored value cards as two separate entities. And in the old statute, stored value cards fell closer to a gift card. And so they did have the restrictions of no fees on them. When adopting RUPA in the new statute, it didn't account for pre-funded bank cards, and it just had store value cards, which then kind of put the two together in one pot and caused complications with the pre-funded cards for unaffiliated merchants. So I think it was an unintended circumstance.
Thank you. Is that, Peggy, is that your recollection as well? It seems consistent.
Right. I think that's consistent because we didn't really, right. We didn't really talk. I have no memory of talking about these fee restrictions not applying to this kind of other type of stored value obligation.
Thanks. Committee members, are there any more questions, or would somebody like to present a motion? Representative Harnett?
Thank you. I just wanted to hear from the Pinots about the CD issue, the certificate of deposit, and the concerns they had that they no longer have. Are they still?
Yes, thank you. Kate has just appeared in our meeting, and you may proceed to answer the question, and also a warm welcome.
Thank you, Chairwoman. Yes, Representative Harnett, thank you for including us in this work session. The credit unions on first reading of Section 2 were concerned how it might apply to our short term, for example, a 2-year CD that comes to the end of its 2-year term, and then you get a notice as the member, you get a notice that says your 2-year term is up, and unless we hear from you, we will just reinvest it in another 2-year term. So I read it first actually and thought, oh no, this means that the credit union will have to then have some kind of affirmative action by the member, which would be a big headache. But the compliance attorney has told me that this bill corrects a drafting error and that this bill will not change what the credit unions do right now in that circumstance. So we are not opposed to this bill.
And just as a follow-up, so this only kicks in at the end of term, what we're talking about here. So if I have a 10-year CD, we're not concerned about this issue until the 10 years runs out. Is that correct?
I believe that's true. I believe Jeff from the treasurer's office might be better able to answer that.
Okay.
That is true.
Thank you. Okay, I'm done.
Thank you. Any other questions by committee members?
I do have one for Mr. Chakoskas, if I could.
Okay.
Are you familiar with, I mean, I want the financial industry to be treated fairly, but I usually don't feel sorry for them as far as how the current economy is going. They're one of the most profitable industries out there. But I do understand this situation. Mr. Chakoskas, can you tell me what it means if we do have $100 bank card? What kind of a fee are we talking to open it up? And then I know about fees that they charge regarding use of it, but what kind of a, I'm looking at what it means to them financially to have these fees.
I can't honestly speak towards that. It probably would have to be a financial institution to answer that. I know the fees will differ depending on the contracts written with those cards.
The reason I ask the question is that it's relevant to whether this is a hardship or not, but I understand. Thank you. Thank you.
Yeah, and I would just contribute with regard to the first section. I think the question is whether the cards would even be offered to Maine consumers. I think that's the question more than the amount of the fee.
My point is that can they make a profit?
Okay.
With status quo law, and that's why I was asking.
I see. I withdraw my comment. I was not tracking. Thank you. Any other committee member wish to ask a question or make a motion? Representative Harnett?
Can't hear you.
I move ought to pass on LD 420. I just like to practice it once before I say it out loud.
Thank you. We have a motion ought to pass by Representative Harnett and a second by Representative Moriarty. Is there discussion on the motion? Not seeing any discussion. At this point, I think that we are ready for a vote on the motion ought to pass on LD 420. And Ms. Annette has joined us with her beautiful background photo.
It's a courthouse.
It's lovely.
We ready to go?
I think we are. Is everyone ready? Yes.
Thank you so much. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Kime. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett. Representative Moriarty.
Yes.
Yes.
Representative Moriarty votes yes. Representative Galgay-Reckett, I apologize.
Yes.
Thank you so much. Representative Galgay-Reckett votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Apologies, wrong button. Yes.
Representative Hagan votes yes. Representative Downs.
Yes.
Representative Downs votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos. Representative Newell.
Yes.
Representative Newell votes yes. Senator Kime. Senator Kime is absent. Representative Evangelos. Representative Evangelos is absent. I have 12 members voting yes and 2 are absent.
Forgot to unmute myself. Thank you very much, Supi, for taking the roll. So that LD 420 passes. And that closes our work session on LD 420. I want to thank the bill sponsor for quietly observing all of our discussion today, and for those who appeared and helped us understand this pretty complex little piece of legislation. Thank you for all your help today. And thank you very much, Peggy. We are done for the day. I would just like to let everybody know what's on store for next week. We'll only meet on Tuesday because we'll be convening on Wednesday and Thursday in Augusta. And on Tuesday, we are going to dedicate ourselves just to finishing up our work on the budget, because our report is due back to AFA by the end of the week. And so Tuesday really is the only committee day we have to finish up that work. And we'll do our usual careful, focused approach on all of the items on our budget on that day and finish it up on Tuesday. So with that, does any committee member have announcements or questions? Not seeing anybody. Does anybody have a motion to amend? I mean, a motion to adjourn.
Motion to reconsider.
No, I'm not going to recognize a motion to reconsider. Is there a motion to adjourn?
So move.
Representative Poirier and Representative Marty, thank you, everyone. See you Tuesday at 9. Take care.
Yes.
Have a nice weekend, everyone.
Yeah. You also.
Wait, aren't we meeting at 10 on Tuesday? Oh dear. 10? 10 on Tuesday. Okay. I'll send a note out to remind people.